realization of fine state and the bail.
So, the third eye is concerned, that is regarding stay of operation of judgment, that may lie over and maybe had after receiving
So
the.
that way, that I am rejecting.
No, the difficulty is that.
You argue the
No,
merits.
let the LCR and evidence is to
LCR
be.
call for LCR call.
LCR and that may can be lie over, my lord, will try.
Let it be there. It's
Yes.
neither here nor there.
No,
And you know that conviction can't be stayed. You know that.
Their judgments are there, I will convince my lord.
Three judgments are there. Everybody is reading that judgment. How many
let it
times?
lie.
I will cite 4 decisions of this court.
Let it lie over, well, I will take my chance.
First judgment is Navjot Singh Sidhu. First you will start with that.
And we will start with Datar and Kumar.
Corruption case, do you
It is
expect
not corruption, he is no way involved, but entangled.
Then you are entitled for acquittal. Argue the matter.
But
Get
now
ready and tell me, I will argue the matter.
no, the CD, no, without the CD, it is case diary, my lord.
I have already called for the.
Yes, obliged.
The moment it comes,
yes,
keep it in track and argue.
My appearance may kindly be noted and free copy be given.
Apology item 89, your lordship.
Mentioning is over. Matter started. Yes.
62.
May I plead lordship?
Yes.
The is convicted under section 13(1)(c), read the section 13(2) PCRT, your lordships. He is convicted 2 years, your lordships.
Okay.
I am also in bail in also during the trial period, your lordships.
Sorry. Admit realization of fine state bail.
Your lordships, sub item 180
And
bail, your lordships. I am during the trial period. I am also in bail, your lordships.
Already order passed.
Yes. Second item, your lordships, the realization money.
Second means it's 63.
Sub item.
There is no sub item here.
Yes, sir. Interim application, your lordships. Interim application.
Yeah.
Realization money, your lordships.
Yes, already passed.
Yes, sir. Yes.
You have got full 100% relief.
Yes,
Why do you worry? Yes.
Free copy and
Yes.
63.
May I please, your lordship? The
Yes.
petitioner appellant has been convicted to undergo RI for 4 years, your lordship.
4 years.
4 years.
How much undergone?
Only from Panchas Act. This no.
Date of conviction.
See.
Obliged, your lordship. Obliged.
64.
He is in custody, your lordship, upon conviction.
No, grant bail. Wait.
Lordship.
Custody bail.
He's in custody, obviously. 4 years he will be custody. 389 benefit will not. Yes. 64. Urgent. Huh? Next week only.
65.
Lordship permitted to withdraw.
Thank you. Thank you very much. Give the responsibility for the petitioner seeks to withdraw this petition. Stands.
66.
What is this matter? When the bail was granted? Bail was granted in November 2023. Grounds? For the grounds? (302).
May it please your lordship. 66.
Hmm.
Item 66. The petition has prayed for cancellation of bail of.
Bail granted by this court.
No, my lord. Bail was granted by the learned district court, my lord. ADJ.
The bail was rejected by this court.
My,
Huh?
my, the rejection of the
Page 17. What is page 17?
70.
17.
That is the bail application of another co-accused person.
That is rejected by this court.
My lord, two accused persons were there. The female accused Nandini Sahu, he was granted bail, extending the benefit under 437,
Hmm.
my lord. The other accused person
Was rejected.
was rejected, my
Right.
lord. Right. Man,
Then he went to trial court.
my lord.
Trial court granted bail.
Trial court granted bail, my lord.
Show me that bail order.
That is it.
Where is that order?
And my lord. That is Annex 3, my lord. That is page number 20.
Hmm?
Page number 20.
So page
Annex
21 come to. That Sanjay Sahu and Tintu, Siddhanta Sahu,
My
they
lord.
release on bail. You are against them.
My lord.
Opposite party. Sanjay Sahu. But if the court has exercised the discretion, what are the ground on merits?
My lord.
Why should I cancel? The trial court gives bail.
My lord, there are circumstances, my lord, the one of the
Maybe bail only, he is not acquitted.
no, my lord, even not acquitted, my lord, the on merits also they did not deserve bail.
Trial court gives bail, we should not interfere.
The High Court has not granted bail, my lord.
That's right, but the trial court only. High court, if High Court would have granted bail, you would have gone to Supreme Court.
My lord, however, even though the circumstances are such that the trial could be hampered at this stage, my lord, because the
See, they were taken into custody on 3rd July 2022.
my lord,
Bail is granted. Today we are in July
24.
24.
My lord, when the petitioners approached this court in time, my lord.
2 years, that's all right.
Well, even
Today they are in custody since last 2 years.
my lord, there are judgments of the Supreme Court that says that even the only period of custody cannot be taken into consideration while.
Yeah, judgment otherwise also.
My lord, however, one of the eyewitness, my lord, and the distance between the house of the deceased person and the accused, my lord, only 50 meters, my lord. And the other accused persons who have been, and there are two other accused persons also. They were granted they were in their anticipated bail application. They were granted liberty to surrender, and their parity may be considered. Until date, they have not surrendered, my lord.
How many witnesses are examined already? Now? How many witnesses examined?
My instruction is 4 witnesses.
4 witnesses have already examined. Right now. The petitioner being the informant. You are the informant.
My lord.
Being the informant.
My lord, the brother of the informant, my lord.
Brother of the
Who
informant.
is the injured, my lord? Informant is the injured.
Brother of the informant and the injured in the instant case has challenged the order dated 16/11/2023 passed by additional sessions judge Kamakhanagar in CT case number 211 of 2022, whereby enlarging the opposite parties number 2 and 3 on bail. The bail order has been passed on merits. The petitioner is challenging the bail, concession of bail granted to opposite party number 2 and 3 on merits. I am not inclined to entertain this petition because the trial court has exercised its discretion and enlarged the opposite party number 2 and 3 on bail. And meanwhile, out of 40 witnesses, 4 witnesses have already been examined. If in any case the witnesses, if in any case the opposite party violate any condition of a bail or attempt to interfere in the smooth trial or try to influence the witnesses or the injured, the petitioner is free to move appropriate application before the court below, seeking variation of bail condition or for cancellation of bail as well. With this observation, the petition is dismissed.
My lord, 8 witnesses. 8 witnesses.
8 weeks. I have given that liberty. You can move application if they interest. Okay. Okay, next.
67,
On
Yes.
25/6/2024 and 3/7/2024. In both the appellants, non-appeal for the appellant. Ma'am.
What is this matter is about?
This is against the final order of confiscation. 2 times my lordship they are not appearing. And this is the third time.
Uh, the dates, when are the dates?
25/6/2024, another is
But
3/7.
problem is, in the proceeding, it is written that at the, as requested, listed, and the presence is marked. How will you say that they are not appearing? These people are creating the problem. If nobody appears, they should write none. But none appear, but there is as requested, please the matter on such as. Next, again, Mr. G.N. Mahapatra appeared on that day. G.N. Mishra, G.N. Mahapatra, and as prayer, leaves the matter. Learned Mr. Das and Council for the Vigilance submits that on 25/6/2024 as well as on 3/7/2024 when the matter was called. None appeared for the appellant, and in the interest of justice, the matter was adjourned. Today, when the matter is called, none appeared. In the interest of justice, last opportunity is granted to the petitioner, to the appellant, read the matter, Monday.
68,
But somebody is not appearing. Why are you writing the name of the lawyer at the top? Routine, copy paste. अभी देखिए तो मैं बताता हूँ.
I may pardon, my lord.
And very unfortunately, what is happening is they copy and paste the appearance and all. In last date, somebody is appearing, the same date names are coming. To the extent for petitioner so and so, and for respondent so and so. In the proceeding, it is none appear for petitioner. I've seen those kind of proceedings. If none appears, how his appearance comes at the top?
May pardon, my lord. My lord, item 64 ର list ଟା ମୁଁ ଦେଖି ପାରୁନଥିଲି.
Pass over. In between, please.
My
Yes.
68,
Yes, 68. 68 on consent, this matter was listed for today. What is pass over?
69,
Next Monday, 60, next Monday, no,
68.
68 and next
For
Monday.
the none appears for the appellant. Please the matter.
69, Miller. In this case, the appellant died in the meantime, and I have filed a miscase under section 394 proviso for leave to continue the appeal, Miller. IA number, that is 2 IAs are filed. One is
Delay. What is the delay?
delay is 120 days.
124 days delay, let it be.
Right. The sole appellant in the
69,
69, IA number 2610. The sole appellant has died in the has died. Therefore, the widow
Miller.
the widow of
Widow.
the sole appellant has moved the present application under section 394(2) of CRCC to with a prayer to continue the appeal. For the reasons stated in the application, the same is allowed. Insofar as 2611/2023 is concerned, the So after the death of sole appellant, the widow of the appellant had moved an application under 394(2) of CRPC belatedly. The said application suffers a delay of about
124 days.
124 days. For the reasons stated in the application, the same is allowed. Amended memo of parties shall be filed by the newly added appellant within a week. Leave the matter in the weekly.
For hearing.
Cost settle may be corrected.
Okay, that's what I say.
Cost
Amended memo of parties. Yes.
Hon'Ble.
Item 71, abated.
Yes.
71,
71, why, your lordship directed to list it in the weekly hearing list. I
Malaj,
have
this
already received the
matter,
paper book.
Malaj, this has been listed on account of ours, Malaj, because an IA is pending, Malaj, 2114 for stay.
What is that I?
For stay of the judgment, Malaj.
No.
Malaj, may I pray this matter be taken up at 2 on behalf of Mr. Kanungo? His
No,
office begs, Malaj.
no special treatment, sir.
Malaj,
It has to be added in the.
no, Malaj, the IA,
23. Why?
IA is pending, Malaj. The
That
IA,
IA has to be rejected.
Yes, she has been
I
dismissed. from
merely
service.
kept it pending doesn't mean that, see, how are you unnecessary wasting time of the court for staying of the conviction? Argue the matter finally. I'm ready to hear the for argument.
Malaj, the only grievance is that if
Let
that
it be listed in the hearing list,
the
Hearing.
weekly hearing list.
the petitioner has been dismissed from service.
In view of the fact that the petitioner submits that in view of the fact that the an application being IA number being
2114, Malaj.
is pending before this court for the purpose of seeking stay of the conviction. The matter is urgent in nature and to be heard with preference. I'm not inclined to give preference to this petition. However, if both the parties are ready, the matter could be listed for final disposal.
Yes, ma'am.
Paper book has been
Please,
supplied.
the matter next Tuesday.
Yes,
Tuesday
madam.
comes.
For
In the
final.
weekly list, it may be listed.
Let it come, we'll see.
24.
Yes.
Weekly list.
Which that report.
Wednesday, Thursday. come. Wednesday. Yes.
Deeply appreciated.
Yes. Sir.
72,
Yes. He said that he lost the file. The time was granted for reconstruction of the file. None appears for the petitioner on the last date of hearing on 25/6/2024. The petitioner submitted that counsel for the petitioner submitted that he has lost his misplaced his file, and therefore time was granted for reconstruction of the file and supply of the copy of the same on the state council. However, none appears today. In the interest of justice, last opportunity granted to the petitioner. It is made clear that if there will be no appearance on the next date appearing, the matter shall be proceeded in accordance with law without waiting for the council. Next week.
73,
Directed to deposit the amount of 70,000 million. The petitioner is staying at UP, and needs some time, because he has shifted to Burger to UP. In the marriage functions, he has gone. At least
Check amount?
72,000 million. 72.
How many time this matters?
No, I think last chance lots में किया है.
What best the court would be to dismiss it
Lots
automatically?
में the last chance lots में give it. Next Monday lots. Next week. Only next Monday. You know, dismiss the. There's a conciliation failed because you are staying at UP, you could not appear, and conciliation failed.
Check amount is 72.
72 million.
Mr.
will be the last case,
Authorized learned counsel for the petitioner on 10/7/2024 had taken time to persuade his client to make good the payment of the entire check amount
Yes.
to the tune of
72,000.
72,000.
Then some more.
However, due to lack of appropriate instruction, he seeks last opportunity.
Yes, yes, madam.
Last opportunity. Accordingly, the matter is leased.
Next month.
adjourned and listed
Next month.
Next month.
Hello.
Yes.
Mobilized.
74, 52. 75.
Mobilized.
That application, my lords, the revision is directed against an orders rejecting an application filed under section 457 CRPs for release of the seized items, my lords. I got the instruction last occasion, lordship wanted me to take instruction. Now the 3 bank accounts of the accused and the wife and son have been allowed to operate, defreezed, keeping the amounts as on the date of house search to be kept intact. The otherwise their salary is, accounts there are
The accounts are being operated, but a
salary
particular
accounts.
amount is
the salary accounts are open.
when?
My lords, 3 numbers of bank accounts have been defreezed, skipping the lien amounts as on date of house source. That is salary accounts of Sri Ashwini Kumar Das, the husband, the man, of course, in the DA case, working as a BDO, my lords. And Moja Button the Katak, bureau number so and so, salary accounts of Jyotirmay Sahu, the petitioner for lordship, the wife, my lords. She is now also working as a section officer in the government press, my lord, getting the salary, but taking the grounds that they are in a state of penury. Absolutely wrong. They are now getting the salaries and the government
Her
service.
salary account is not.
Yes, her salary accounts of Srimad Jyotirmay Sahu, wife of accused, bureau number so and so, and one account of Sri Aniruddha Das, white account of Sri have been defreezed, my lords.
Defreeze.
Allowing them to operate to get the salaries, my lord. Keeping all those.
Right, pass it over. Let them come. Let her come. Kefali Das. Let her come. We'll dispose it up. Yes.
76. What do you mention?
For what?
Item 76, my lord, on behalf of my lord, praying for an adjournment next week, my lord, any date.
Include kar de. Next.
77.
Obliged, my lord.
Yes. Yes, sir. 77. Sir is waiting. Why don't you ask?
86.
86. I'll take it up immediately after this matter, sir. Please come. Yes. 70?
77.
77. How many time you will take the time? And consider the petition submit that he would verify from the record the period of undergone. Verify from the record, pass or go. He is supposed to verify from the record the period undergone. 86 you take.
86.
Yes, sir.
May I please
Yes.
Here, the petitioners have been convicted, have been tried and convicted for an offence under 147, 506, and 149 IPC. The allegation is these petitioners entered into the land of the informant.
Sir, please use the mic.
Entered into the land of the informant and tried to, and seeing them, threatened them, so they left the land, plowing, they were trying to plow other persons, so they left. And this occurrence is of the year 13/7/2009. Huh?
Yes.
This file is not available in our office. Let it be taken up on Friday. In the meantime, I will collect it.
I'll give him a fight.
Okay, please collect from sir.
I'll give him. Xerox judgment copy, dita jayega de.
Yes. Let me.
77. Because I have to find a period of undergone.
Has he come? Nobody has. Pass out.
78.
78. None appears on behalf of the petitioner. Reishi, Mr. Sahu has been appointed as MAK Spuri. Have you informed him? Reishi directed to supply. Inform Mr. Sahu. Huh? Last time it was supposed to inform. You should have informed that Reishi is directed to supply a copy of the brief to Mr. Sahu and inform it. I pass it over to Parliament. Wherever there is MAK Spuri, we want to finish it up. That's the idea. Yes.
79.
Item 79, my lord, I pray
Call
for
him at
more.
2 o'clock and get ready. Yes.
My lord, item 79, my lord, I pray for some more time, my lord. The letter we have sent, my lord, not yet returned, my lord. Any reply, my lord. Either,
What letter, sir?
my lord, to the petitioner, my lord.
Hmm.
That is, this is a case against conviction, my lord. He has been convicted for offence under section 409. And his age was at that time 51 years. Recently, we sent rescue post, my lord. That letter, 2 addresses there, my lord.
In the year 1995, 2006 it appears.
Man.
I don't know. 2006 he was 35 years.
55 years.
This judgment source, but maybe 95 also he might be the same time. It's doubtful.
तो कोविड टा जाइए तो सेतिलागी एज कम बेसी रे मत
1 week पर लगाओ. Counsel for the petitioner submit that he would seek appropriate instruction from his client regarding his well-being and whereabout and leave the matter. Okay. Yes.
Item 80.
Item 80, I want to waste time because I contacted the person that they
2014 sir matter. It is against conviction.
Conviction.
What was the age at the time of conviction?
6 months and 1 year.
50 years. 50 years at the time of filing of the appeal.
Appeal.
50 years.
Appeal 50 years. That is 2014.
Same.
And must be also 60 years. Same mode of control. Counsel for the petitioner seeks to get instruction regarding well-being. Yes. Next.
Last 7.
Hmm?
The last 7.
Same mode of
81.
Huh? What is this? Why are you asking for time?
Against the conviction manner, revision against the conviction.
See, adjournment is not a routine thing. You can't make up your mind 1 week. We are adjusting the board accordingly. We can't adjust the board according to the wishes of individual lawyer. Try to appreciate how will we, this is 2014 matter. Last time you short time. Before that also none appeared. See, when the matter was taken up on 18/6/2024, none appeared for you. And the next on 26/6/2004, you requested for time. And now you are again requesting.
Last chance. Now,
what is this matter? Let us see.
revision against the conviction.
What will you do within 1 week?
I will prepare now.
Prepare. I let it be there on the board. You prepare and tell me whenever. Let it be there. Also, weekly. Yes. Let it go to weekly to get ready. Yes.
82.
The problem is you start entertaining adjournment, then the entire the sequence is getting collapse. We least according to a method so that matter could be heard and disposed it up. In between, if many of them you will take adjournment, then the entire system goes for a toss. Yes.
82.
82. Okay, Kumar Sahu.
Your conviction 324, 34 IPC. Conviction under 324, 34 of IPC.
They're supposed to file written submission also. Right on non-APS for the petitioner. On 21/6/2024, on behalf of the petitioner, it is submitted that the council has lost the file and wanted to reconstruct the same. 2 weeks time was granted. And it was also directed that the petitioner should file written note of submission not exceeding 10 pages. When the matter is taken up today, none appeal. In the interest of justice, this is the matter on next week, and it is made clear that if nobody appears on the next date of hearing, the court will proceed with the matter without waiting for the appearance of the counsel for the petition. This is the matter. Yes.
83.
Private.
14. This is against what? Permission.
Private particular.
138. Huh?
How much files are there?
I'll just check it. I'll just check it. Okay. This is against vigilance.
125 proceeding.
Right on. The pertinent matter is arising out of a proceeding. Proceeding under section 125 CRP. When the matter was taken up on the last date of hearing, that is on 3/17/24, none had appeared for the petitioner. Therefore, in the interest of justice, the matter was adjourned. None appears for the petitioner even today. In view thereof, the petition is dismissed. Yes. Next. Dismissed.
84.
My lord. On behalf of Mr. Dolly, kindly adjourn to next week. The file is not received, my beg your pardon, my lord.
406, my lord, arrived 2 years. Appeal confirmed.
No, lastly, the matter was listed
28
and you had requested for time. You had requested for time. That day you had the file.
No, Lord, I am not. Associate me.
Mr. Dalai, SK Dalai.
Yes.
You call him. Last time he sought time. That means he must be having the file. Otherwise, you would have intimated the court that the file is not there. I would have allowed for reconstruction of the file. So we pass it over. Just ask whether he has a file or not. Otherwise, I'll pass a direction, give direction to the registry for allowing you to reconstruct the file.
Okay, my lord, pass over.
Yes, pass over. Yes. When you are appearing, get full instruction. Otherwise, don't appear. If somebody says that go and get an adjournment, never come to the court like this. You must know what is this matter. Get the file. Just go through.
Yes,
why should you be embarrassed because of somebody's request? Some lawyer want to get an adjournment. They use you. They tell outside, go and get an adjournment. Jolly well, you come and ask for time. You know nothing about it.
Matter is 2014.
Never even do that. When somebody is requesting you to get a pass over or adjournment, you must ask what is the matter is about.
Yes.
Or hold the file.
Yes.
What is this? Is not a disrespect to the court without holding a file you are appearing. Don't do that. Go and ask and you only come after the lunch. Okay. Yes.
85.
My lord, kindly have a glance to last order. This case, the petitioner were convicted under section 490-34 IPC. In the trial court, they are sentenced to undergo RI for 2 years. In appeal, it was modified to 1 year. In the meantime, the dispute between the parties was settled. The informant and her husband were living together, my lord. They have also a son already passed out the metric. The informant filed that appellant.
IIC was supposed
directed
to verify.
Yes, my lord, that
And today I have
instruction
also
has not
called
come.
both the parties.
Why instruction has not come? This is
Chandipada.
28/6/2024.
My lord, my instruction is IIC has visited the house of the petitioner, taken the statement of the informant. Today I have also called the informant. Kindly pass off the matter after lunch. They
Yes,
will
I'll
remain.
take it up at 2 o'clock. You
My lord.
bring him.
Yes, my
And
lord.
if the IIC is not there, please call him and let him appear in VC.
Perhaps my lord, he had given the instruction, my lord, that is available.
If it is there, it's all right. Otherwise, call him, let him appear in VC.
Yes, my lord, yes.
We'll dispose it up.
My lord, two matters are there, my lord. Noting is there, the connected file criminal division 424 of 2014, since it is not scanned, not listed. সেটাই মধ্যে আসলে দুইটা কেস সহ্য
Call that file also.
424/14
We'll dispose it up. Both are same.
এতে 414 রে ফাদার ইন ল
ঠিক আছে, we'll dispose of both.
মেলা
2 o'clock, huh?
মেলা
Yes, specialist, let me be specialist.
Pardon, my lord, item 82.
It is just over. Wait, you have to wait. 82. 82, I have a pass some order.
Yes, my lord. 24. Urgent to 24.
Urgent to 24. Yes.
87.
87.
87 May, please, ma'am.
Yes, sir.
My lord, the petitioner challenged, the petitioner in this case is the victim of the occurrence. He has challenged the order of the appellate court, that is the additional sessions judge Dharamgarh, passed in criminal appeal number 52 of 25, thereby confirming the order of the trial court and confirming.
Acquitted. Trial court acquitted them.
No, my lord, convicted. I am the victim in this case. I have challenged the order of conviction. Thereby, the appellate court has released the accused persons on under PO Act.
That part you are challenging.
Yes, ma'am.
Who all are appearing for the petitioner? Petitioner.
Opposite party number.
What was the sentence?
But the sentence was
RI for 3 years.
RI for 3 years.
Of and 307.
No, my lord, not 307. 324, 30 and 34.
Admitted by the trial.
324. 324 convicted. 3 years sentence. Appellate court enlarge you on PO.
PO.
Given the benefit of PO, he challenging being victim.
My lord.
Yes.
I gave tomorrow my.
No. We will not go according to your convenience. Get the brief, I'll pass it over. Pass it over. Get the brief. Only limited question whether PO should be granted or not.
My lord. And my lord, PO should be granted, and also, my lord, the acquittal under section 307.
Have you challenged the conviction? You have not challenged the conviction.
But there are two questions in this case. One is PO, it should be acquitted under PO Act, and another thing, if
Not PO Act is not
released under PO Act. Pardon, my lord.
And he has not challenged the conviction.
No, my lord.
That danger is there. If that concession is withdrawn, then you have to go to custody.
Yes, my trial court has acquitted 307 and has convicted 141.
324.
323. 1 year, 2 years.
Yes.
Not 3 years.
Okay.
Yes, no.
1 year and 2 years. So, madam,
Yes.
that is the.
Then that doesn't mean that you are directly entitled for PO. That's what he's challenging. You have not challenged the conviction. You would have challenged the conviction. Then you are in a very difficult position. Be ready. I will alter the sentence. How much you undergone?
Undergone
307 means
307.
he might have undergone for some period. Two of you, huh? Okay, acquitted by the trial court, but during trial you must be there in the custody.
Trial bail trial
I'm not asking on merit whether you were in custody or not for some some periods.
trial time bail
Check it up and I'll take it after lunch. Check it up.
Obliged.
If they have already undergone for some time, then we modify the sentence to undergone. Gone.
Madam. Obliged.
You will be satisfied.
He will withdraw this petition. He will be in hospital.
Obviously.
Because he has not challenged.
He is not challenged.
Yes.
But PO, he is enjoying the PO, the benefit. If the PO benefit is taken out, then they have to go in custody. They can't challenge it also. Time, but the conviction is way.
My lord, another thing that he has to take instruction. The appellant number 1 is now perhaps
75.
79.
That is the ground जो there is a pure chadle.
That's a good ground.
Still challenging the back in 2014 he was not 75 years.
But now it's on right.
Oh, yes,
Appellate court has given, I'll extend it in view of the fact that he is 75.
But appellant number, the accused number 2 is not that old.
For how much?
50.
45 thila, the year 14 or 45 ply, 55.
What was the injury?
Lord, injury simple in nature, but in head. It was in head with an axe.
Put an end to it. Why unnecessary? Why to trouble? Put an end to it.
307 Lord, judgment bhi achi, the injury is sine qua non to the.
But you are not challenging the conviction.
No, Lord, that's what I said. Two challenges on 2 grounds. That is one that we released on PO, and the second one is the acquittal on 307. 2 grounds.
And page 15, that PW12 doctor has given the injury.
Simple.
Simple in nature. That I agree, my lord. But it was caused by axe on the head.
I think you should put an end to it.
There's an intention to kill.
Put an end to it. You just seek instruction. Today is Monday. Put it day after. Seek instruction. And what I'll do is, what was the fine amount?
Fine amount was 5,000.
5,000.
No, my lord. 5,000 PO actually.
I was not there.
The bond of 5,000 sentenced.
You tell me the fine amount.
5,000.
I'll
5,000 of PO.
I'll increase it substantially.
PO
At the time of releasing on PO, 5,000 cost best.
But I'll modify the sentence and impose heavy penalty, fine.
My lord.
And that will be given under 357 compensation, at least.
That will work.
You will be satisfied.
Well, that will be helpful.
You come with instruction day after tomorrow.
Obliged.
I'll increase the fine. Okay, I'll dismiss the petition. However,
day after tomorrow, holiday.
Thursday.
I'll increase it to, tentatively I'm telling you, increase it to 25,000.
Deeply obliged.
Ready to pay 25,000. What poor man you have beaten him?
Poor man.
Otherwise, go to jail. You have not challenged the conviction. I'll withdraw the concession. You have to go to jail or pay 5,000 was already imposed. Hey, have you paid it? You have not paid that also.
Bond
might not have paid. PO is granted. You might not have paid. So I'll increase it to 25 or maybe 20.
That will be justice,
Maybe
my lord.
20.
That will be justice served, my lord.
19.
Yes.
19.
19?
Yes, 19.
19.
19.
Seek instruction.
Obliged, my lord.
88. Or do one thing. Get a draft up 15,000-20,000, whatever you want to. Draft in his name up for the petitioner.
Petitioner.
I'll not record anything. I'll give that and finish it up here. So everything will be.
Let them get
instruction, whatever. Otherwise, I'll pass an order. Yes.
Deeply obliged.
88.
88, my lord. Next week or any other day, my lord.
Yes.
Chair had not been come.
Chair called for non-APS. Non-APS for the petitioner.
Here he has challenged that the appellate court has passed the order of rehearing. Appellate court has passed the order of rehearing.
Rehearing.
Because this is that matter that the magistrate he was not HR. The TI period, magistrate conducted the TI period, he was not HR.
Okay.
That reason
Or the trial court executed.
Trial court has given 7 years conviction and
Okay,
fine
7.
2,000. That is 457, 395, 25 answer
And appellate court set aside and sent for retrial.
for a rehearing.
Who will challenge it now? Accused.
My lord, accused and challenge.
Why?
My lord, the appellate court order, my lord, page 32.
30?
32.
Was there any stay? In this?
Stay, my lord, is on 8/8/2014 stay was there.
They were convicted under?
Under section 457, 395, 25 answer.
Okay. And appellate court has reversed it and sent it back for re-hearing.
Because they were identifying the KI, accused persons.
Was there any stay?
Magistrate was not an exam.
So further proceeding was stayed in 2014.
I pray only next week, my lord. File is not with me.
File will never come to you because you are enjoying a stay.
No, my lord, the file is not with
Because
me.
you are convicted by the trial court.
My lord,
Appellate court has
my lord,
reversed it
Friday-
and sent it to retrial. You came here in 2014, got
my
a
lord,
stay.
on Friday it will be.
The file will never, definitely miss.
No, Friday, my lord, the matter can be taken up Friday.
Thursday. I'll vacate the stay otherwise.
So Thursday, my lord, matter can.
Thursday. Learned counsel for the petitioner seeks an adjournment. Adjournment, on the last date of the hearing and on 25/6/2024 as well. He had sought a time. This is a matter where the petitioner was convicted by the trial court on appeal. The conviction was reversed and the matter was remanded for a rehearing. The petitioner had challenged the remand matter before this court. And on 8/8/2014, the trial court proceeding has been stayed. Therefore, it is made clear that no further adjournments shall be granted. Yes.
Entry order to continue.
89.
Entry order to continue till Thursday.
Entry order to continue, I have indicated.
Pardon. I mean, difficulty in Portner file, that will be better. I hope, yes, I have not gone through the list, the noting that.
Let it be, you in the.
But I mean, pardon, in one matter, 68, I am talking with Mr. Simon Das, Senior Standing Counsel Vigilance, to take up, he is not free. After lunch also, my death sentence will continue. On that, non-appearance लिखा है तो काट दे. My lord has already adjourned to 22nd. Non-appearance लिखा है तो मैं काट दे.
68 non-appearance.
68.
अरे weekly ठीक है.
I have talked with him, he said, even I was.
Yes, weekly. This 89 is weekly.
My lord, I mean, pardon, another matters, my junior will there.
Yes.
89 year lords.
89.
Pray for next week on behalf of PK Samantra.
Weekly.
90.
90 may pray for one passover. I'm expecting the photocopy the judgment.
Yes.
I will press your
Pass.
91.
Yes, madam.
May I please your lordship? My lord, the present petitioner is a 72-year retired doctor, and he is aggrieved by the order dated 7/11/2019, my lord, in which the 457 petition of the present petitioner to release the amount and the other documents such
What is
as,
the stage of trial?
well, not yet started.
Yes. Yes.
My lord, and the bank accounts and the ROR, sale deed, ATM, passbook, and the passport also seized by the vigilance department. In this case, the wife is the accused of a trap case, which the FIR registered against the wife by one electrician that she taken rupees 5,000 for release of.
What is your prayer? Prayer is to release to 2,50,000 rupees.
And the documents such as passport and passbook, other documents, which is kept in the vigilance department since 2018.
18.
My lord. And trial not yet started.
Yes, Mr. Das.
But an affidavit has been filed, notes. I've copied to my learned friends. The affidavit was filed on 24th June 2000.
What is the stage of the trial? In one order, I have seen that there was a direction to get instruction. What is the stage of trial? This is a matter of 2018. Trial might have been proceeded in a,
In fact, there are two cases, my lord. The one case was a trap case. The other charge sheet has been filed, notes. Thereafter that they entered into the house, they went for the house search. Then the DA cases was registered, notes.
Against the husband?
Against the husbands. Husband, and both are facing, my lords. And my lords, we have filed an affidavit.
He is also an accused. No, Dr. Birinji Nanda. He is
Yes, yes. In fact,
My lord, 2018 allegation, that is DA case. Then after in 2022, they make another affair. In 2022, after so many years.
no, so many. That's that.
Maybe that's the different story. Whether you are entitled for the release of this thing or not.
And my father's accounts, my father who is no more, he is also an OS officer. His cell deed RORs also kept in the Department of Vigilance, my lord. My son's accounts are also frozen. My
On that, my lords, I have got a positive instruction.
No,
in
see
fact,
the ROR, sale deed and everything. Why are you keeping, you give it and taken undertaking that they will not alter will not get third party interest. Simple.
the possibility of transfer.
And as and when required by the court, they'll produce it. As simple as that.
Sell deeds.
Sell deed, obviously, all the original document, give it.
The possibility of
LIC bonds,
transfer.
so many.
That order, the court is
Lordship,
going to pass that order, and as and when required by the trial court, they'll produce it.
Yes, my lord. On that issue, my lord, the sale deeds and the passports.
And all the original document, you give it to them.
LIC.
You can't conclude the trial for such a long time. Give the original, as and when required, they will produce you.
My lord, so may I suggest one thing, my lords? During the lunch hour, I'll sit with her.
Yes.
I'll just find out what are the documents.
So I'll pass an order saying that all the original document will be given to
No.
as and when. I'll tell you whatever document. As and when required by the court, she has to produce.
My lords,
without fail.
Just give me 1 day, my lords, I will take instruction. I'll sit with her, my lord, during lunch hour. I'll come back to your lordship.
Let us sort it out.
One matter.
What are the things, my lords?
Justice. My lord, I will.
A 300 matter fixed here.
My lord, I beg you. A big
I'll be knowing.
Wait, you coordinate with him.
What are the specific documents?
Day after. I'll put it day after Thursday. Thursday. I'll put it Thursday. Sit with your senior and find out which are the documents which can be given to you.
Like the sale deeds.
All the original documents will be given to you. You will give an undertaking to the court that as and when required, you have to produce your report. Your purpose is heard.
I'll just take the instruction, my lord. Day after tomorrow, my lords.
Item 92.
But I invite you a cup of coffee during lunch hour.
Yes, you must. Yes.
May it please your lordship. May it please your lordship. My lord.
Yes, Mr. Mishra.
My lord, item 92, your lordship, the petitioner is challenging the order of rejection of his discharge petition under section 239. There is absolutely no material to implicate, even if the entire prosecution is believed and accepted for a moment, your lordship.
Charge has been framed.
Yes, your lordship. Rejecting my 239 petition.
What is the stage of trial?
Not yet begun. It is fixed to 19th. Your Lordship has permitted me to take adjournments in this ground. Your Lordship may only permit me to place order dated 14/7/2022, order number 2. I am reading only paragraph 3, my lord.
Yes.
Page,
Learned-
page, Mr.
Pa-
Page.
Order number 2, order dated 14/7/2020.
14/7/2022. 14/7/2022, para 3 he reading.
My lord.
Learned Standing Counsel.
Learned
please.
Standing Counsel Vigilance is directed to examine the records under which the decisions was taken to allot shop rooms to allottees and find out the specific role of the petitioner in the decision-making process and accordingly file a report in this court indicating the role played by the petitioner. My lord, there was an allotment of shop rooms. Some were
The
given.
report tell me, report has come on record?
No, my lord.
Huh?
No,
Then
my
this
lord.
order is not complied as yet.
Not yet complied. They are not complying. There is absolutely no material, my lord.
Yes, Mr. Das.
I'll
See, this order was passed in 2022.
Maybe inadvertently we could not get that orders copies. No, I'll get it today, my lords. I'll
And
file it.
thereafter you have not complied at all.
The report has to be filed. No, I have not gone through.
By way of last and final opportunity, one more chance is granted to the counsel for the vigilance to comply the order dated 14/7/2022. If the affidavit in terms of the order dated 14/7/2022 is not filed, adverse reference will be drawn against the vigilance department and the
Sir-
matter will be treated.
Serving a copy to me, my lord. Serving a
Record.
No, Mr. Probably it was my mistake.
How much
my lord.
time?
I could not.
How much time?
Probably it is my mistake, my lord. I could not communicate this court.
Anyway, I'm giving you time. I have indicated that if you don't file, then adverse reference will be taken.
Lordship fixed it.
It will be taken that there is nothing, no specific role is there.
Lordship fixed a date.
You tell according to your convenience.
Next week, my lords.
I would take one more week because peremptory order that
Correct,
passed. So give it 2 weeks के बाद. 30th, huh?
My lord. Your lordship may only
And give a copy, free copy to Mr. Das.
Diplo,
If
please.
we may forget it.
My lord, the copy of the affidavit may be given to me. A copy, prior hand.
I'll keep advance, Mr. I'll
My
keep
lord.
that.
My lord, only one prayer, your lordship.
May I have the temptation, my lords, to pray for lordship, my lords. Can I get the copy of that 14/7? Because
Both the
lordship
orders.
asked.
Give copy of both.
Diplo, please.
Give a printout.
Diplo, please.
My lord. My lord, may I pray one thing, your lordship? In this order, your lordship has permitted me to seek an adjournment on the ground below, on the ground that the case is mentioned and only one.
Arrangement continues.
My lord, your lordship may kindly indicate it, your lordship.
Without that order, you are competent to get an adjournment.
Yes,
No, like I say, your lordship, they are not granting. 18th, the date has been fixed.
Interim arrangement.
That order was not passed.
Not passed.
Not passed. Mr. Manage, he can manage, my lords.
No,
So
my
Mr.
lord,
Manage cannot
your
block.
lordship may kindly indicate.
No, if there is not order, no order, I can't pass that.
There is an order, my lord, paragraph 5. Paragraph 5, how my learned senior is saying there is no order?
No, my order sheet says.
Okay, 92, na?
Yes, paragraph 5 of the order, 14/7/2022, paragraph 5, it is opened.
Paragraph 5 is there. Okay.
Yes,
My
then
lord.
it's all. 14/7 order is not with me.
Paragraph
That
5
point.
repeat. Paragraph 5. Okay.
Your lordship may permit me to seek one adjournment on, as mentioned. Your lordship.
Paragraph 5, I will repeat it.
My lord, obliged, your lordship.
93.
May I please, Your Lord? The petitioner challenging the legality and correctness of order dated 10/1/22 passed by the Lawrence Special Judge Vigilance, wherein the Lawrence Court below framed the charges against the petitioner under section 32 and 31 CD of the Prevention of Corruption of 1998. The minor prosecution case is that one
Against the framing of charge.
charges, minor. Trial has not yet been commenced.
What is the stage of the trial?
Has not yet been commenced.
Huh?
Has not yet been commenced.
Commons?
Has not yet been commenced.
Yes. Was there any stay in this?
No, my lord, there is no material, your lordship kind. The lordship kindly see. Yes, 32, my lord. Yes, 32.
Yes.
The present petition is the video. In charge video
the
Your accused number?
petitioner is Gagan Bihari Beheraman. Allegation minor that the minor collector approved for renovation of tank minor pond, renovation of pond at the cost of rupees 1,77,898.
Yes.
And charge is that the amount has misappropriated and some work was done, entire work has not been done. But the cashier of the office of the BDO deposited taking responsibility, deposited the entire amount. Deposited the entire amount. But in fact, some work was done. Some work was done, and assistant engineer, two assistant engineer, namely one Ashok Kumar Ashok Panigre is cashier minor. Two assistant engineers, Sadasiva Behra and Akshay Kumar Behra, who measured the minor pond and submitted report. Took measurement and submitted.
Who is Prashant Kumar Das?
Prashant Kumar Das is the second petitioner, madam.
Technical assistant.
Technical assistant. He only his work is minor only for running bill. Work was measured by the two assistant engineer. Master roll prepared by Gramo Rojogar Sanjog and Sebok. Two person prepared the master roll and in their respective laborers account, payment was made. Measurement was done by the concerned assistant engineer. File was given to me for approval, for payment release. I only simply sign. My role is, so far as video is concerned, I have no role.
Are you saying that your signature is so valueless?
Valueless, my lord, it is not possible to go to the, what I humbly submit.
That is your job, sir.
My lord, my job is to see that.
You are the BDO, you are a head of the institution.
My lord, report only.
And your signature is not so cheap that you can sign anywhere you like.
After receiving the report from the assistant engineer who took measurements, two assistant engineer different, and also report
Contractor.
of Gramo Rojugar Seboko and Sanjay Joko.
Why the money was deposited then?
The cashier taking responsibility deposited the money because collector directed to deposit the money. Collector, as per direction of the collector directed the responsibility to.
That will not pass away.
If Lordship permits, may I suggest nothing? I agree with the fair submission of Mr. Dr. Lenkam, my lords. In fact, I don't extend my solidarity with regard to the second case. I verified, I've examined this.
Second case in the sense?
The Prashant Das, my lord, who is the GPTA, Gram Panchayat technical assistant. What in this entire gamut of facts, my lords, this gentleman, the Prashant Kumar Das, my lord, he did the first thing, prepared the bills. Then then the check measurement was the assistant engineers. Then the cashier authenticated the bank scores. And when thing was routed through the table of the present one, he has to sign. The way I signed when my stenos or clerk.
Then why you have made him accused? Well, you could have made him a witness.
Then this is my submission for lordship. Lordship cannot record my submission. I have examined so far this case is concerned. He did the entire foundation.
Shall I take cognizance of what you are saying?
No. This is my submission that he only put the signature. That's what
you could have made him a witness. You yourself have made him an accused. Now you justified.
But
even today you can make him an approver if you want.
Actually, my lord, the video has no role. Only the in charge video file came, my lord. In fact, five steps. One step is preparing the bill. Second is check measurements. Third is the cashier to authenticate. And my lord, the fourth is the placement of file on the table of the
there is a hierarchy. He's the head of
application
the
is required.
And you say that the other people have really done it. If other people have done it, therefore a senior officer is there.
It could be pressure and approval.
You can't see vicarious liability is obviously there. And now vis-a-vis his role, you have to see. If down the line all the officers have really done something and he has signed it, that liability comes to him.
Correct.
Unless the prosecution says, no, he is innocent and we will make him a witness. He should have wiser enough to make him a witness.
Correct.
To prove the case against all of them. If I'll pass if I'll discharge him, the benefit will flow to the other people.
Similar.
Is it not a foolishness of first grade on the part of the vigilance?
Anyway, my lords, this was the submission of so far the Prashant Kumar. The second case is that.
But you are not appearing with Prashant.
My lord.
Are you appearing for Prashant?
My lord, I am appearing. He is appearing for both the cases. Both, my lord.
You will only prepare the my lord bill on the basis of a report on the basis of measurement taken by the assistant engineer and grammar says report. Everything he has given to the file. Therefore, I only prepare the bill, not only prepare the bill, not final bill, running bill, account running.
See, that
And
those things has to be
responsibility taken
on fact. Those
and
things has to
to
be
your
tested in
lordship,
the
humbly submission, your lordship is right. I am not, but one thing your lordship consider, this is GPTA is a contractual appointment, my lord. What is my role? My other services I have regularized, my lord.
on these
Other-
kind of equity doesn't play a role. What to do?
But taking responsibility that Panigrahi is, he has deposited the amount, my lord. Besides, my lord, that two assistant engineers against who submitted the took measurements, they have a case against them has been abated because of
That
death.
is, according to me, that is much more dangerous. He has basically pleaded guilty.
And as per direction
Your
of,
complicity is
as per
now
direction of the
to some
college-
extent
My
it is established. I'll give
And
liberty,
after, my lord,
I'll give all the liberty to you to argue
My
all
lord,
this point. Before
I will give you, let it come other day, I will take my lord. So for other research is concerned.
Is there any stay?
No stay, my lord. Trial has not yet been commenced. Your lordship grant interim stay.
No,
Interim
I will, if they stay there, I'll vacate it and then I'll adjourn it. That's what I was thinking of.
No stay, my lord.
Very difficult to discharge, sir.
Let it come other day, I will satisfy.
Adjourn it, sir, on this case. If there is anything you tell me can be done somehow to help this guy, then I'm ready to do it. But I don't think the fact that one of the co-accused
my lord,
has
your-
accepted his
Suppose-
guilt and make the payment good.
Suppose a client come to me, is give me false document on the basis of false document. My lord, I filed the case and the case is allowed.
But you
So-
are, see, the problem is
Subsequently
you are admitting the fact that you have signed. That itself is enough for the purpose of framing charge.
My lord,
Thereafter, you will be acquitted. It is a case of acquittal. If you want, I will record everything and give you all the liberty and expedite the trial.
Let it come other day.
These are the best relief one can give. So that you can be acquitted. You will be acquitted. There is no doubt about it. For the purpose of discharging, you may not have a case.
Let it come other day.
Adjourn. Please. And try and find out if any point is-
Chapter.
94.
My lord, answer the matter.
What is the status?
My lordship wanted me to take the start to get the status of this case. But here also another case, my lord, if I sit with my lord, what are the documents actually about the documents he has not mentioned all those things. I'll just take I'll spend some time with me and I'll find out what are the documents they want so that I can talk with the officer.
You don't have instruction.
But in the lunch hour also, I'll talk, see you last time.
No, this order was passed in June. 25th June 2024.
I've sent the letters, but I've not received.
Is the department is not furnishing information to you.
No, in fact, because of this intervention of some, I've sent the letters, but I'm expecting, I'll expedite the matter day after tomorrow also.
See now, can't it be a ground for
To get the status, but there is no difficulties. I will get it.
I'm looking
Tomorrow.
I'm looking at the matter in the otherwise that these are few matters where the instructions are not coming for. I can summon the Director General Vigilance so that we can sort out all the problems.
No, instruction I will
The
be
other
getting.
matters also we can think of.
Sometimes we have to give a telephone call after sending letter. That I will do it today, my lord. Let it come tomorrow, my lord.
18th, huh? Let it be on 18th. Mr. Das, General Counsel for the petitioner, submits that he could not obtain the instruction in this matter. Seeks one day, seeks an accommodation, leaves the matter on 18th. Yes. Yes. Continue, Guru. Report has been called. Report has been called in item 1 to item 2 to item 3. Mr. Rijvi, item 2 to 43.
43.
In how many cases you got?
Almost in 34. In 34 cases, we have received the instructions.
How many cases the appellants have died?
Around 20 minutes.
20.
To be approximate.
Have you checked that there are 2 appellants?
Yes, madam. I have checked everything.
Have you gone through?
I have gone through the instructions also.
And point out those matters we will await.
My lords, we can just go serially, my lords. I have
Yes.
marked.
Okay.
Shall we start, my lords, or after lunch we can start?
No, we'll do it. If you just I'll go 5 minutes, I'll come and
My lords, as your lordship pleases.
within 5 minutes.
My lords.
Password data already. Password data already.
भाई प्याजी
Yes.
Your lordship, the petitioner that the appellant died, we had this morning. You have to file a petition for substitution.
We file it.
No, but then your lordship may not say a bit. Just I am asking for time for.
No, once it is informed to the court that died, it is awaited. You move application, who stops you? Tomorrow come.
Again, recall, my lord. Again, I am just seeking plain time.
Same thing. Either in a awaited petition, you move the application, or a pending petition. How does it make difference? Experience of your level.
No, I am not on that. I am not on that, your lordship.
As if you are speaking.
Why I am saying? Your lordship may call it after 15 days.
Why should it be pending? You move application 15 days. I'll take it. I'm giving you this thing. Anytime you can move application. Who stops you? It is awaited means what? It need not come. It should be kept in the registry.
It's a
in true sense. It is not dismissed.
I have already filed a petition. That's what.
The moment then you bring it on record, I'll take it up anytime. Anytime you.
That's why I'm asking your lordship.
Anytime you are come, I'll allow that application. That's not an issue at all. Yes.
One. Next week,
yes, let us come. Item 1. Item 1. Pass over at 2 o'clock.
Can it some other day?
Tell your juniors. Yes.
My lord, 64, my friend is here, my lord. Item passover item 64, bail matter.
Passovers will be taken up at
2 p.m.
2 o'clock only.
Man.
Yes.
Item 1.
Yes.
My lord, item 1.
Item 1, my lord. Though it is a vigilance case, my lord, last occasion Russia directed me to take instruction wherever of the appellant. My lord.
Yes, yes.
I have got an instruction, my lord, from the IIC Chhatrapur. He stated that the local inquiry, it is ascertained that the village such and such. I conducted local inquiry, but nobody can able to say about the present whereabouts of the appellant Krishna Chandra Behera.
And my lord, same was the situation with us also. We also made a local inquiry, and the situation was same. We were also not able to trace them. So that is the
What
reason.
do you propose in such situation? We can't presume that he has died.
Man.
Then what is the age? Age is Krishna Chandra Behera is only 63. We can't presume it. So in this kind of situation, I think the only option is to appoint a amicus curiae. That's the only way of doing it. You suggest someone. Miss
Mahapatra, Miss Mahapatra.
Yes. Appoint amicus curiae. Report has come. Pursuant to the order dated 24/6/2024, a report has been placed by Mr. Ragada, the counsel for the state, inter alia, stating that the sole appellant in the present case is whereabout of the sole appellant in the present case is not known to anyone in the locality. Same is the instruction Mr. Rizvi has also received from the department. In view of the same, don't tell the quantity of history, Reach is directed to supply a paper book, take the paper book and get ready.
You are still directing me.
It's a 1992 matter. I am not going to give you any time. And when tomorrow?
Madam?
Tomorrow?
Madam.
Tomorrow. Get ready tomorrow. Paper book today you take it. 92 matter. 92 matter. 18? 18 batch. 18 batch matter will not take much time.
18
here batch matter. Only abatement and appointment of 19th at 2 o'clock. Come, we will finish it up. Because it's 92 matters that unnecessary.
Your lordship directed me to take instruction from 2 PSC, my lord. One page Chhatrapur given, but in fact Boriguma page concerned, my lord. There, my lord, the village name is not mentioned. Only Boriguma. So that is the
Boriguma itself is a village.
But the IS is not sent any instruction.
Any. Okay. Next. Item 2.
Item 2, managers have received, he is alive.
I'm there.
He's alive.
Yes.
Then
Conviction is
Weekly, my
for
lord.
the
Weekly, sir.
weekly.
Yes.
Item 3.
What we are trying to do is we sorting out where in which matters appellants are really alive or not. Once it is sorted out, then we can proceed.
Transfer it to weekly.
Yes.
Item 3 and 4, managers. They give us some more time. We need some more time. Let it come on 29th, managers.
29th, all the matters.
Yes.
Whichever you have.
Whatever is left over in this
29.
list can be taken up on 29.
2 and 3.
2 and 3, yes.
Make it sure that all instructions.
My lords, I will.
Yes.
3 and 4. 5.
Item 5.
Yes.
Okay.
And lords, here also it's difficult to trace the whereabouts. My lords. They have done local inquiry twice, but they could not establish any contact with the.
What is the age?
That's age at the time of filing was
94, madam.
Yeah, 94. So this also can be taken up on 29th. We'll give another attempt.
One more attempt.
Yes, 29th.
29. Yes.
Item 6.
Yes, 6.
March. 6 also same, my lords. Let it come on 29.
In which matter then you got the instruction?
Rest, thereafter, my lords, almost all cases we have.
Okay, 729.
7 also same, my lords. 7 and
No
8.
instruction, yes, yes.
No.
Okay.
7 and 8.
8.
7
Okay.
up to 8. Then, my lords, from 9.
And he is appearing. You are appearing for?
8, item 8, Lordship.
Yeah, what is your instruction?
Lordship, appellant has died, so substitution will be filed.
Right. Let counsel for the petitioner. When he died?
Died recently, exact date.
Then counsel for the appellant submits that to the sole appellant. Sole appellant in the present case has expired. Therefore, the present appeal stands appeal.
So substitution will be filed.
You file.
File it.
You file it.
You have a right to file. Yes.
9.
Yes. 9.
He's alive.
Alive.
Yes.
Nobody appears for the petitioner and takes to conduct the appeal. The judge appearing and we have seek adjournment. 23. There is a counsel appearing. He is alive.
Yes.
Weekly put it in. Yes.
Am I case, minutes?
No, he is appearing. Somebody is appearing.
10.
Item 10. 10 sir is there.
Must not be alive, I feel. Because he was 63 in the year 85.
Same alerts could not be traced.
Because 3 letters have written from that address.
But he's not residing on the said address. That is the difficulty.
Then what to do in this? We can't keep on waiting for what is the age?
It will be around 104 if it will be count. Because the husband says 63 years in the year 95. 63 means 39 plus 39.
It's about 100. Whereabout is not there.
Let us try the last chance.
We have done twice.
There is no
Twice
point. You keep on trying, then the age is increasing.
Yes.
4 gradual.
How can I presume taking the life expectancy?
As no instructions are forthcoming from the appellant side on that ground, maybe.
How can I dismiss a criminal appeal?
No.
Can't dismiss the criminal appeal. You have to find out some ways out. There is no point keeping it pending it also 1995. Let us see the age. I'll pass appropriate orders. Let us see the order. See the, in the year 1995, his age was 63.
My lord.
In the trial court judgment indicates.
And he was appearing through a state defense counsel.
Yes, yes. 63, 95. Now, what would be the age? Count it exactly. Huh? 91. 1990.
The judgment was delivered on
16/11/95.
95. 63.
94.
94.
Let us see the chart. This is
9.
10. Item 10, na?
Yes, madam.
Yes. Let us see the chart.
39% issue. 39% misle kete hela? 85.
85.
Judgment was delivered on 95. 94. Yes of 85.
94 years old.
94.
94 years. As on date.
It's a case of 83, 84. Judgment was delivered in the year 95.
No, I'm wondering if the age is written in the judgment doesn't really reflect the real age, in the sense the whatever is age is written in the charge sheet would be the right age.
Idea.
Many times what happens is the charge sheet age is written in the judgment.
Usually.
So what, in the charge sheet, it is not exactly visible. Charge sheet is there. So paper book is ready in this case. Huh?
Paper book is not ready.
It's there, but the only problem is not at all visible. No?
LCR soft copy is there.
LCR soft copy charge sheet is there. Yes. Soft copy. File is not there. Okay. No, charge sheet is there, but
If we go by the age reflected in the judgment, then he'll be around 92 years as on date.
29, it let us last and final opportunity.
Charge sheet 53 years.
Huh?
Charge sheet 53 years.
53.
Again.
53, that is 1988. TR case is 1988.
Charge sheet is of 87.
87, okay. 87, 53. Right. Now count it. 87, 87, right? Count it.
$94.
94.
Same 94. Last attempt you take it. Otherwise, what we'll do is we'll dismiss or something. We'll do. Otherwise, there is no point. Yes. $29.
11 my lord, he is alive.
Alive.
May I please your lordship? My lord, I may be permitted to submit on behalf of Mr. Dipti Samu.
Yes, sir.
My lord, I may be permitted to submit, my lord, on behalf of the appellant.
Yes, yes. Tell me, sir.
My lord, this appeal is directed against the order of conviction passed by the Learned Special Judge Vigilance.
I'll hear you. I'll put it in the weekly list. I'll hear you. We have verified that your client is still alive.
Yes, my lord.
Yes. Put it in the weekly.
12.
Yes. Next. 12.
12 my lord will be taken around 29.
Huh?
29. 12. Item 12 is taken around 29. Awaiting instruction.
Awaiting instruction. 29. Yes.
13.
Okay, 13.
13.
Krishna Chandra Sahu.
13 days we remove about it. $13 may be kept at Passover.
Passover.
Yes.
Passover. Passover. Yes.
13 days.
14.
14 he is alive now.
Please, lordship, paper book may be served on me. Lordship, I will argue this matter.
Argue, we'll take the entire record in the pen drive. Get ready, because this is a matter of 97.
97.
I'm putting it in the weekly list and take it from this court that no adjournment will be given.
Yes, lordship.
No question of adjournment in old matters.
Yes, sir.
Taken up means it will be over. Yes.
Item 15. 15 my lord, he is dead.
Dead.
Yes, since 27/12/2021.
Right down. The sole appellant in the present case has expired on
27/12/2021.
The persons to the earlier order of this court. Mr. Rizvi got the instruction from the department that sole appellant has expired.
SP Vigilance, Sambalpur.
SP Vigilance, Sambalpur has instructed. The sole appellant has expired. Awaited. The appeal awaited. Yes.
Item 16.
Let's say item 16 to 20, then 22 to 20.
Item 16. He is dead.
Dead.
Similar matters, similar appeals have been filed by this present appellant who is dead. The serial numbers are 16, 17, 18, 19, 20, 22, 23, 24, and 25.
Right. All the numbers. Huh? Oh, there's Minakatan Sahu.
Yes.
Minakatan Babu.
Babu, yes.
No, Sahu. What is
Babu.
the sole appellant, all these items. The Mr. Rizvi, pursuant to the earlier order of this court, had sought instruction from the SP.
SP Vigilance, Sambalpur Division.
Sambalpur Division. As per the instruction, died on. The sole appellant has died on
6/3/2014.
6/3/2014. The appeal stands awaited. Yes. Thank you. Much obliged. Minakatan.
21. Yeah.
Yes.
21. Alive minutes.
Alive. Weekly. Yeah.
Yeah.
26. 22. Minakatan.
22 to 24.
Minakatan.
For the appellant, but my file has been misplaced since 19 meter.
He is no more.
Wait.
He's no more.
No more.
No more.
The Ms. Rizvi, on instruction from
Sambalpur. SP Vigilance, Sambalpur.
Submits that the sole appellant in the present case
Passed away on 1/11/2023.
1/11/2023. The appeal stands awaited. Yes.
27.
Yes.
Dead mallards.
Dead. Yes. Mr. Rizvi, from instruction.
Inspector Police Vigilance, Jagat Singhpur.
1 minute. Don't in between. How? What is this?
Sorry, sir.
I'm dictating an order. You come.
Sir.
Maintain some decorum of the High Court at least.
Sir.
You can't expect that anytime you get in and your matter will be taken up.
There are another matter is there.
Maybe whatever. Everybody is busy here. What have you said?
And that's Inspector Vigilance, Jagat Singhpur.
Mr. Rizvi, on instruction of Inspector Vigilance submits that the sole appellant in the present case has expired on
16/11/2013.
16/11/2013. The appeal accordingly stands admitted. Yes. Yes. What do you say?
Item 27.
27.
28.
This is the matter. Abated. He is died. He is died. Your client has died.
Instruction.
28.
Who will you send to the heaven? Will you send someone?
No.
You tell me the name. I will record the name. That so and so says that he'll send his representative to the heaven to verify whether he died or not. He is saying he died. I recorded it. Date he has given.
Okay.
Still you doubt.
I have not seen
He has died. So it is abated. And if you want to move application under 394, you seek instruction, move application, and abatement will be recalled and the matter will be heard. Okay. Okay.
28 may be kept as Passover, my lords.
Passover.
29th, my lords, on 29th may be taken up.
Yes, 29.
29, my lords, on 29th, my lords.
Or 29.
Yes.
A week, instruction awaited. 29. Yes. 30.
30, my lords, expired.
Instruction from
SP Vigilance, Balasore Division.
SP Vigilance, Balasore, Vigilance. Expired on
29/5/2021.
29/5/20. Awaited. Yes.
31.
Let's say item 31, praying for an adjournment. Let's say
1 minute.
He is alive.
First see whether he's alive or not.
He's alive.
Alive.
Alive. Weekly. Yes.
Much obliged, let's say.
32. 31, he is alive, my lord. Yes.
Sorry?
Yes, he is alive.
He is alive. Yes. It will go to the weekly, get ready. Yes.
32.
32.
Alive, my lords.
Alive?
Yes.
Okay. Weekly,
33. Same appellant, my lords.
Hmm?
Same appellant, my lords.
Same appellant.
Yes.
The weekly.
34.
Alive?
Yes.
Alive, no?
I haven't received any instruction on this.
But
She is saying that.
Yes, she is alive.
Okay. Weekly.
Yes, your lordship.
Get ready, but
Yes,
don't
yes,
ask for agenda.
35.
My lord, on behalf of Miss Nanda, my lord, the appellant-
Wait. Let us see. Your client is still alive or not?
Yes,
Alive?
yes, he has just approached her.
Yes.
Take up the case.
Weekly.
My lord, obliged.
36.
My lord, Alip, my lord, he is 47 year age in 2000, in 1998.
Alif.
Alive. Weekly.
कितने हो रहा है?
30.
37.
37, he passed away.
Passed away?
Yes.
The sole appellant. Instruction from?
SP Vigilance, Sambalpur Division.
The sole appellant in the present case is expired as per the yes. Date.
11/10/2020.
11. Yes.
38.
Petitioner died, man.
Died.
Yes.
Date.
No date has been mentioned, but it has been written since 2011.
2011. Even the counsel for the appellant submits that his client has expired.
39.
I'm for the appellant, my lord, on 39. I'm for the appellant, 39. 39 item 39. I'm for appellant.
Let us
Yes.
see.
Yes.
They are not able to trace the appellant.
What is your instruction? Alive?
No, my lord, we have no interest. I mean, we have sent a letter, but
29.
so-
Let it be on 29. You also try. Let us see.
Item 40.
With your lordship. 40 is Alif, my lord. I have got.
Alive, no? Let us see what is his instruction. Alive?
Yes.
Yes. Weekly list.
Yes, weekly list in the next month, my lords.
I'll accommodate you whenever. No problem. Get ready. Yes.
41.
41?
Alive.
Alive.
I haven't received the instruction on this. If he says that he is alive, Lordship may record it.
Okay. Weekly.
42.
41 लिख दियो. Counsel appearing for the appellant submits that his client is alive. Therefore, the petition, the appeal is otherwise read the matter in the
42.
We are also awaiting instruction.
We are also waiting the instruction. Let's see.
29.
29. Much obliged.
43.
Sub item 43, sub item 168 of 2006. They are alive.
Nothing.
As far as this Upendra Patnaik is concerned, Upendranath Patnaik, because he is alive.
Alive. And how many witness? How many? Upendra is alive. Then okay, weekly. And what about Ram Chandra Naik?
Alive.
Ram Chandra Naik also alive.
Well, as Ramchandra Naik we have not received.
Yes. Tell me, madam. Huh?
Ramchandra Naik.
Alive.
Alive. Yes, he
Both-
says alive.
Both the appellants are alive in both the appeals.
Well, I'll just record a statement also.
She's not sure. She's finding it out in mobile.
Is he alive?
If my Mr. Das is saying that. I'm not sure what should be my passive offer.
29 minutes.
29. 44.
43 up to 43 the instructions were sought for. And my lords, in between I have passed over 2 items. That can be also taken up on 29th.
You know instruction.
I have the instruction, it has just mixed up somewhere.
Okay. I don't think much instruction you got. In one matter only, Minakatan, there are 5-6 matters.
And out of 43, 33 instructions we have received.
33 means out of that 7-8 matter, one person.
Yes.
So much instruction has not come in two sense. 29th and for 18th, how many cases you have got instruction?
18 minutes is still coming. As on date, 5 instructions I have received. 18, there are not much matters. It's not as like 43. It must be in between for 20, I think. Out of 20, I have received around 5 to 7 instructions.
See, if you can't get to the instruction, it's a very difficult thing. I can understand.
No,
but I expect that they should make efforts.
No,
Otherwise, on that day, I'll pass an order for the Director of Vigilance to appear, so that it will be easier.
Yes.
They'll take.
My lords, it's not that they're not trying; they are doing the due diligence. The problem is that, my lords, they are not able to trace them. And this being an investigation wing, my lords, we have dearth of manpower also. Like against 1100, 700.
But at the same time, you are prosecuting someone.
Yes,
you should know whether they are alive or not. What would the court can't go and keep on searching? If the petitioner says that I have no instruction, and I have,
that is the problem.
The court has to depend upon the prosecutor.
Yes,
only.
ma'am.
If the prosecutor says no, I don't have instruction, what to do?
We are doing due diligence, madam.
So that's the whole difficulty. Yes. Then yes. Some passport matters were there. Passport matters.
Pardon me, Lordship.
Yes.
Lordship, item number 28 state 6 for an adjournment, Lordship. In that matter, Lordship, my name may be reflected because it's an old matter, for example, Lordship.
28
Abhas Manti name may be reflected.
28. Okay, passport.
No, those passover matters can maybe fixed on 29th. It's 2 passovers.
Yes, that's item 13 or something.
28.
28 and 13. 28, then 13, 29. Yes.
28 and
13. Yes.
Passover.
2 o'clock. Any other matter? Okay. At 2 o'clock then.
That's
good.
ମୁଁ ଦେଲିନି ଦିଟା ସକାଳେ ରଖିବା ପାଇଁ ଗୋଟେ 13 ରେ ଗୋଟେ 48 ରେ 48 ରେ ରଖିଲ ତମେ 13 ରେ କଣ କଲ?
See?
Patients have been. Are you ready? How much time will it take? Ten minutes. Yes, Lordship. So that is regarding that rejection of 457 application. Not there at the time of call, but in the larger instruction. In fact, the whole important instruction, but specific stories that with regard to so those things in this case is one instruction that. But that is. These are the matters not getting matter. What is it matter? Matter is about the condition on the section 395 for like that. On the now, but on the deposition of PW1 and PW2, appellant section of service convicted. For the police. That at 2 o'clock for the way, it's not they ask order to be they are acquiring they go with the auto and not service 6,000 rupees for which we are taken to what it is good. My auto that auto not the auto driver has not been. Next, conviction on the section 395. 395, that's 5%. But here, I think next to that, he is stating that the informant is stating that the persons returning from the front side. Doctor is the PW7. PW7 is that stating that C type of injury night se asichi tapnka paku PW7 lo
ସେଇଟା ଗୋଟେ point ସେ ଯାହା କହୁଛି ଡକ୍ଟର ର statement ସେଇ ହିସାବରେ ମିଳୁନି। ତାପରେ accused himself informant is one accused। ତା ଆଗରୁ ତା against ରେ ଅଛି ତାପରେ ଯୋଉ driver ଅଛି FIR he has not written the FIR is written by PW4 who is the driver। This driver told I have written that FIR in the police station by the instruction of the police। So my humble submission is that it's a planted case। It's a police instruction I'm against you have 3 points। First point is the auto in which they not been seen, not seen, the driver is not examined. Second is since there are only 2 persons, it can't be 395, minor, or 390. Okay. And third one is the life of the fire is who has applied the fire is he is stating that is written in the police station or the instruction of the police। Next point is that doctor's statement and the informant statement is not corroborated regarding the doctor examine for what? ସେ କହୁଛି ମୁଁ ମାଡ଼ ଖାଇଲା ପରେ ଡାକ୍ତରଖାନା ଗଲି ଏଇ ଡାକ୍ତର ମତେ ଟ୍ରିଟମେଣ୍ଟ କଲେ but there is no no ନାହିଁ okay that's it doctor's evidence is irrelevant there are 3 points what do my lord there is no witness to the occurrence also no TI period of what is the time my lord 2 PM on the eve of leave in the public place also the public place 3 PM only that is just time here also so that time the incident occurred there is no eyewitness except the PW1 is the complainant natural behavior in my trend they need for more money they might have done all this that is also a natural behavior yes more specifically my lord TI is not conducted in this matter and he never the PW1 also the statement in the deposition also contradictory all of the independent witnesses corroborated the court is the name hello yes name by the informant from whose position is identified my lord crucial aspect is that the PW number 4 who is the scribe how does it make difference meaning the case and example my lord it is non-accused identified my lord so why is why because of the previous enmity maybe because of integrity on facts of my lord name accused identified accused the enforcement of 2021 paragraph 5 the possession of to bring the charges having witnesses out of 10 witnesses named in charge sheet whom PW1 Subhash Chandra is the informant PW Chandra is the doctor my lord PW1 paragraph 6 has a categorical statement that on that day of the holy festival paragraph 5 was going to Kirana side to purchase goat for sale of mutton Dolo festival and carried rupees 10,000 with him of this aforesaid purpose. He has further stated that as soon as he reached at a Kosila Kunta shop, there he found lodging for Bola Panda, Ikki Mahanti, and a Kutta Behera sitting in the shop and asked him where he was going and when he replied that he was going to purchase gold. Accused persons particularly Bola Panda asked him to give ₹100 for their drink and when he refused the accused persons, snatched out his basket and gone running back and accused the same and thereafter collecting the aforesaid article when he was going to Pulina side and reach the bridge of the canal that is Bahamara Gavira canal. Then all the accused persons wrongfully arrested him and accused Bola by means of an empty where what something for deal with him he for which he fell down
The Bholapanda didn't raise his left arm by standing over it. The other accused persons threw away his bicycle and kick and snatched away the 10,000 from his pocket and accused fled away. Due to assault, he lost his sense and regained the same during evening hour. Then he went to the Waterside Hospital for treatment, and in the same night, he reported the matter to the police by the exit number 1. During cross-examination, he has elicited that he received statement from the Ranjit Naik along with order to supply mutton for him for the purpose of marriage of his daughter. People 2 and 3 have supported that they had advanced 6,000 to the informant people 1 for supply of mutton for the purpose of marriage feast of his daughter. Therefore, after Rajavati Monday, a searching prosecution was directed to these witnesses, but they did not break down under the pressure of the such lengthy prosecution. The only contradiction that he has elicited the one that he has not stated that Bholapanda assaulted him by means of an empty beer bottle, but stated that Bholapanda assaulted him by case of problem. Minor contradiction. Clear case of problem. Like, supported by are not true. What was the sentence?
5 years.
5 years.
5 years. Undergone?
Undergone.
More than 1 year they were in custody within 1 year.
Take it up. Undergone period and tell you. I'll convert it to 390.
My predicament is that the lower court lawyer who has supplied the brief, after contact, he is telling that there is no connection with those persons, and so last 2 occasions I could not appear for that reason.
Now you are there, how is also there, and in the case of 392.
And the youth leadership that is not whispered mallet is known to each other mallet. Maybe is not.
My humble submission is that whatever that's allegation of 6,000, that 6,000 has not been seized from the appellant.
20,000. From whom he has after robbery, they'll keep it. They wanted for drink. They might have been there.
How was that connection?
See, wrote from some person.
392. Already undergone, tell me. I'm trying to adjust that undergone period or always. 5 years, I'll give it for 2 years. Sentence me. Not be less than 2 years. Go. 2 years for sentence. Already undergone period, you say. Revision, I think. You have to make a doubt, take it up, take the record, time to and tell me undergone period. I will make it. Sir? Before break. It will not be adjourned, it will be there on next. Next, 85. But in this case, the petitioner were convicted under section 483, section 34 of IP sentence
right for 2 years. In appeal, sentence was modified to 1 year. In the meantime, they study with the two, staying together, they left into solid, now solid, they, report has also come, report has also come from this one. Report police. They are staying together. Event was taken up for hearing on 28/6/2024. The following order was passed. First is the order. Inspector of police in the station based on record. It is instruction dated 14/7/2024. In view of the aforementioned development, so who is appealing? The informant, informant, Timothy, what is their name? Mendaki Maji. Informant in the present case, Mendaki Maji, who had filed the affidavit dated 24/7/2018, which is form part of the record, also present in the court, and clear form. Indeed that he indeed has filed the affidavit, and their living life has revived. And she is after consumption, taking into consideration the aforementioned presidency, the revision petition is allowed. The judgment shown to set aside. The petitioner is there are two cases. Another one division, today special. Both the same order. The petitioners are recruited from all the charges, and they want it for permit by them to discharge. Both the matters disputed. Same order. And you know,
sometimes. And actually, I'm busy with that other cases.
we have been waiting.
Yes, madam. So let me this is case notes.
Made, but you have to take it.
You
have to convince him that.
Let him face it, because I will be depending on two judgments. He will be similar other two judgments. I'm expecting another judgment.
In that's also we have to,
No, your is on the date of the name is for accused, but the date or notes to proceed that to face the trial. That is the simple point on that. You not sorry.
Directly
Give me the citation, then I'm
Giving you copy. And let's down to the concluding para, that is last page.
No. Following this, Jitendra Singh, this honorable was already passed the judgment. I have got that copy. I will come back another papyrus part. Two cases in my favor.
This judgment has been overruled.
I don't say, following this one also.
Alerts, this judgment says, if charge has not been framed, then offences under chapter 2 cannot be tried by special judge. It's not competent. Actually, it is para 45, it is clear.
Really. And what are the facts in this?
Facts is that, my lord, the petitioner is the wife.
Yes.
Non-public servant. The allegations inside 109 abatement.
The husband died.
Died before charge, before charge. And died on 23/10/2023.
Okay.
Hello. Now, my lords, this para 45 says that if the the public servant is died before
Wherever written that he died on.
my lord, I can make it on record, my lord.
Invitation, what are the grounds? On merit you are saying.
Meantime, during pendency of this division,
He died. Then your ground is.
now tell that you are suggested about.
Have you placed that ground on the court?
My lord, I am not, I can bring.
Anyway. Oh, I understand that, sir. Well, for merit, I say that why are you going into merit? That is why I'm.
Yes.
Directly.
Where we come?
Lordship permits. Although this judgment, Lords, this honorable already passed the judgment, I'm just clear, there is a immediate judicial opinion. What I suggest, Lord, I'm not, I'm holding the copy, Lords, I'm not giving the copy, this case has not been reported.
Why? The Supreme Court judgment is binding it. What?
No, I don't stand on this. What I suggest, let it go tomorrow. There was the same notice, Lord. Because I will place it tomorrow the judgment of my son report. And following the Supreme Court judgment, and just place it. Lords, you can have a glance, it's possible. Because
In that case, charges framed.
yes. And he's saying that
What other applicant? In this case, he will charge also.
same set of facts. And the thing that thing, the case is immediately consider the thing that thing 2014-11 is 6724. Let me talk tomorrow. That's what I was praying for tomorrow.
Yes.
I'm thankful my Lord of has given me the judgment of Jesus.
Just run through, huh? What is this matter? 95. What is the matter? Remand in something. Hearing. The matter was again on 17th and something.
Thank you, sir.
And sort of thing is sent to the construction. Today we will likely present even APS for the question. No? So this is in the interest of business, we should try it. Huh? Nothing is there. Okay. 97. 97. Already said to army customer, I will get written and all this. And it is one and a half only, right? One for here, no? Construction is ready. 28. 98. What is the dispute? Where is it? What is the dispute? Last time, it is the what is the dispute? Survey surveyor. No, maybe it's something. Right. Right, who knows? Then it's ready. One of these. Ready. 95. Nitrogen and 100 mallet. It's not again present mallet. This matter will take around 3 minutes. You'll come to 3 feet. You need not understanding. Well, present in the code mallet. These are against the conviction mallet. First case 498, mallet 100 mallet 376. There are 2 cases. Often mallet. Yeah. Last one. The item number 98 will taken on Friday. These 3 or otherwise again. But it's not there. You just remind 90, 100. 101. SI for 1 year. 23 and a 4 of repair. He is not very appealing. The taken up color this matter 725. Right on. Appointing my geometry. He is the petitioner has been consistently not appealing in this matter. And the last lead appearing, the court has already indicated that in the absence of the petitioner, MAK will be appointed and non-APS for the petitioner today. Therefore, maybe the court will appoint the copy of the payments applied and get ready. Not 11. Yes. Yes. Phone number also. Phone number also. Yes. Click to. What to do? These matters are pending. This is for people. Array for 7 years. Yes. 103. Immediately there is election. Yes. Yes, madam.
Maybe it's election. Lord, on behalf of this member, this is a case, the conviction is under section 92 of the Factories Act. Conviction is for 6 months SI and 10,000 fine. For contravention of sections 6 and 7. The allegation is that the factory was running without license and registration. My lord, the license had been applied for 2.5 months before the inspection. The license was applied for in June, and 15 days were left to the expiry of the 3 months. There is a deeming provision in the act.
You have any judgment, if license is applied for, there is no criminal intention.
Yes, my lord. It is not an offense of moral turpitude, my lord. I just say that the imprisonment part, if that could be.
Probation of
No. My lord, the 6 months SI, my lord, if the fine is increased, that is okay, but
offense under this provision.
my lord, section 6, subsection 2, which was pleaded by the defense counsel in the lower court, but it was not accepted.
Let me check. We have let me check. What is the meaning? Mr. Rada, let's check it up. What is the meaning? Or fine or and fine.
Or fine or both. Provision.
The only allegation is he was running without license. What is the factory?
My lord, it is Mrs. Omkar Steels Private Limited. Steel.
Constitutional imprisonment term which extended to 2 years or with fine, which may be extended to 1 lakh.
1 lakh.
Or both. Which may extend to 1 lakh. If contraction continue.
Let's see. Then the fine will go to.
My lord,
The fine will go to.
up to 1 lakh, my lord. 10,000 was
Fine
the
will go to state or it will be.
treasury. State.
It's like kind.
It's not mentioned.
This is what factory you are talking about?
My lord,
Oil.
Mrs. Omkar Steel Limited.
Then you pay 1 lakh.
My lord, if I may, my lord, this section 6, subsection 2 was pleaded by the defense counsel in the lower court that if on an application for permission in clause AA of subsection 1 accompanied by the plans and specifications required by the rules made under clause B of that subsection sent to the state government or chief inspector by registered post, no order is communicated to the applicant within 3 months from the date on which it was so sent, the permission applied for in the said application shall be deemed to have been granted. My lord, this was not accepted in the lower court because just before 15 days, my lord, there was a letter that in your drawings, two things are not shown. You show them and compare with the letter.
You have applied.
We have applied in June. And my lord, the right now the offense is basically non-compliance with the letter and not actual that it was running without a license.
Okay, you keep your points in writing by tomorrow.
My lord.
Take it. 75,000.
My lord, if it can be.
Factory.
My lord, if it is 10,000, my lord.
10,000 impose 6 months. So 6 months part I
wish to. I will try to convince your lordship that there is no offense.
I'm already convinced. That's what I'm saying. 75.
There is a deeming
I
clause.
can increase it to 1 lakh.
My lord, just please one more thing.
Whether the benefit of deeming provision will be given or not, that is the question. Whether you validly applied or not, that is another question. The trial court is doubting that. Appellate court has upheld that. The two courts have said that whether you have applied or not, that is also a doubtful thing.
There is proof of that. Application proof is there with the challan written.
Findings, my lord, therefore it was mandatory on the part of the accused to obtain license and registration in respect of his factory, which was not complied by him.
That's there, but he is getting a giving provision. If he is applied, and if you don't give the license, it is deemed to have been given license.
My lord,
So after the deeming provision, he seeks the benefit.
my lord, I wish to place another deeming provision which is available in the Odisha factory rules, which has not been taken in the lower court. But as this is a criminal case,
Judgment declare give your written out.
my lord,
Argument heard, judgment trigger, give the counsel for the petitioner submits that she would give a written submission. The written submission is provision is also in written. And within 2 days. Within 2 days. Judgment. You give it within 2 days with provisions and deeming provisions.
My lord.
And the finding that you have applied for it.
Yes, my lord.
Then you get benefit. Otherwise, I will.
My lord. Obliged.
Very, very good argument. The deeming provision you will be out of. If that deeming provision.
They have not taken that plea, my lord.
May not be, but if he has applied for it, the deeming provision has to be ready. For years together, if the application is not processed, how can you see mentally where from you?
They have to file the, my lord, the order section 1991, my lord. Additional evidence, my lord. That has not been done.
That is what I'm saying. If he has applied for it, then the mens area goes.
How can the court believe that they have applied, my lord?
Without finding, the finding has to be there. That's what I'm saying.
Accepted, but still it has been said that because the offense was complete on the day.
That part of finding you reproduce.
My lord.
And you have applied for it. The court might not have believed it.
My lord.
If this court believes that yes, you have applied for it,
My lord.
then the mens area part goes.
Yes, ma'am.
And deeming provision will.
My lord, if I may place one more. My lord, this has not been taken in the lower court, but there is a deeming provision in the Odisha factory rules also. It does not correspond exactly to the section 6(2) of the Act, but there is in the rules it is that there is a proviso provided that if a valid application for the grant of license has been submitted
That's
and the required fee has been paid, Lord, from day
valid application is there or not? That is the question. The question of facts.
My lord.
You have to satisfy the question of fact that there was a valid application.
That has been clarified in paragraph 8, my lord. Did 1, the accused himself. Did 1, my lord, the defense witness, 315 my lord filing. He has stated in his evidence that he has already applied for license and registration of the factory and also deposited registration fee through challan amount which is 8,750 for license fee for the year 2002, my lord. And security fees. But no document is forthcoming with regards to deposit of fees by him. Rather, the document filed by him not proved in this case or marked as exhibit go to show that submitted application from the for grant of a license.
That is the finding. Finding says there is no valid application.
Perhaps it has not been appreciated, my lord. I have it in my hand.
Oh, those things are exhibited. No? These are not writ petition. These are on the basis of evidence.
My lord, this is the evidence. There is a challan.
No, whether these were exhibited.
Perhaps.
No. That's the problem. You try to find. See,
it's not exhibited.
We are not in a writ petition or admitted.
My lord.
You have to show the evidence.
My lord. This is the evidence right now.
We are in the revision, my lord.
Yes,
we
my
are in revision. Try to appreciate.
2 courses.
Still, you have a good case. Prepare it.
My lord.
If I don't agree, with your this thing, because a very poorly conducted trial maybe, so the fine amount will be slightly lesser.
The lower court has held that it was the application was made after the offense was complete, but it was actually made on 2.5 months before the inspection itself. With valid challan.
Madam, that may be fact, but whether these things have come in evidence or not, that is the question.
Perhaps not been taken. My lord.
That is the whole difficulty.
My lord.
You prepare within 2 days.
Obliged.
You have a good case.
Item 102, my lord.
See, if the problem is he has all the documents not exhibited, what to do?
But the accused himself are cited as a defense witness.
Item
315.
Item 1.
Also scope on our part, 319 has to find before the application that has not.
Item 102. Let's go to next week.
I'm going through 1 minute. 102.
102. Next week or there?
But Mr. Mahabharata appointed as amicus. I would take
My lord, 101. I have adjourned it. 102.
Next week. Hold.
101.
Under amicus curiae.
I am permitted to submit. Amicus curiae. Appointed.
101.
101. See, the earlier preemptory order was passed, and last time I said that if you don't appear, I'll appoint.
The last occasion I was ready to argue, but at the last moment, so I'm ready to argue.
Next Yeah, item 100 kilo. 101. Weekly retain करो, so so appears करो. Out में तो माफ करो.
104. 101, madam. Next week.
104.
101, I am ready, madam. 101 is ready. 101, I am ready, madam.
3 o'clock I am going to hear the matter. I retain it.
Yes, madam.
Yes.
104.
Let it be retained. Yes.
105. 104 adjournment.
No. It is the least it will be.
105.
No adjournment. I was saying. Appears. None appears. 1 minute. None appears on 11/10/2023. Thereafter on 9/4/2024. And lastly on Mr. Tripathi appears. V.K. Tripathi. Huh? Yes.
106.
Let it be there in the list.
107.
Have you seen what are the against any interim order against anything you have seen? Revision against charge. Take help from Mr. Gowda. Just see if the revisions are against framing of charge and all.
No matter, all are confirmed.
Or,
All the hearing conditions. All the-
Have you checked it?
My lord.
If
90
any,
to 117, assigned to me, my lord. All they are confirmed.
please help him out. Just see if revisions are against charge and all.
No matter.
Those matters might have been influxed.
All the matters are confirmed. Hearing. 19 onwards, where it will find something. Hearing matters, all hearing matters are confirmed.
Yes.
May it please, Your Lordship. Item number 107.
107.
Yes.
Hmm.
My lord, in this case, the learned court below convict the petitioner for SI for 1 year, Your Lordship, and fine of rupees 500. The section is 25 of the Arms Act, Your Lordship. Your Lordship, in this case, my lord, the prosecution case is like that, my lord. He have the barrel gun, SBBL licensed gun, but he can't renew the license. For this, that aspect, my lord, on 21st November 2000.
Not renewed, but is kept in your possession.
Not
used.
Not used. It is a licensed gun, not used. It is in my house, and the ADM under the direction of ADM booth, they raid the house and they get the gun. That is only, Your Lordship.
Show me any judgment. We says that mayor not possessing license and applied for it.
My lord.
You have applied for it?
Ye applied, Your Lordship may kindly.
There is no mention here.
Your Lordship may kindly come to page number 99, 100 and 101. The DW1 and 2 statement, my lord. But the appellate court, my lord.
For what? What do you want to say?
The statement, Your Lordship. I want to read.
What are the points you want to?
Here, my lord, the DW stated, my lord, he, along with the accused, presented the license and also applied for the license. They get the money receipt, but they can't submit the money receipt to the police official. In this case, money receipt not seized, Your Lordship. But he stated, I already submitted my license for renewal and I deposited my money. The DW2 also stated my
accepted.
My lord.
But
So,
on the day the raid was taken place, that day you had no license.
No license.
You show me merely not having a license and applied for renewal. No
the mens rea,
mensaria is attract.
my lord, I searched one case law that not exactly matched to that matter, but it's similar. I will submit that case for your lordship, but not exactly in this aspect.
Read 25. Answer. You definitely get judgment.
My lord, for the probation of offender act, I get the,
Probation of offender act, you may get it. That's not issue. Issue is
I will get
if
the,
you applied for it, then there is
On the
no
particular
mens
date,
area.
on the date of occurrence, my lord, he has no valid license with him.
but I applied.
But he has applied for it.
That is not there is no such evidence, my lord.
For DW2, that's why I'm saying.
They don't stated, but there is no such a scarp of.
Read
paper, my
25.
lord.
If you have content.
We are not educated.
Now, what will be the situation? If somebody has a license done, the license is expired. He has already applied for it. Meanwhile, you read it.
He has not applied.
Can you bring 25 into?
He has not shown any document in which he has applied, my lord.
Yes, that is true, my lord. I have not shown any document with respect to I applied for
So
the.
he has a license, my lord. That has already been expired, my lord. On the date of particular date, my lord, he has having no valid license.
But
So
the
the
evidence
offense, my
which oral evidence which he is reading out,
DW2.
says that he has applied for it.
That has to substantiate with the documents, my lord. Since there is no such, for that reason the court will validate the.
You prepare.
Well,
Next.
your lordship, reserve the order. I will submit the case law.
No, lot of I'm reserving thereafter. Everybody is vanishing. Then I have to research myself. I know that.
I will.
You don't want to work, and you expect me to work.
No, my lord. I will definitely.
And that will be a burden on me. No, you research and give me the judgment.
My lord.
Let it be tomorrow. Whenever you get the judgment, tell me.
I will.
I'll reserve it.
My lord.
Simple.
But probation offender is applicable in arms act, your lordship.
Are you conceding
On that day
conviction?
also,
No, I will search.
You concede the conviction, probation I will give.
I will
You are
search.
aiming at a acquittal. Why don't you show me the judgment?
My lord, my
You
lord. I
can be
will.
acquitted also.
Your lordship.
Next week. Next week.
Weekly return. How many?
The moment you get that judgment, you
I will
please
mention.
so that I can take it up because
Good.
it is heard.
Grateful, your
Small
lordship.
point. Okay.
108.
And see the deeming provision if you have in the arms act.
25, my lord.
Eh,
It is applicable, your lordship.
No. There must be some deeming provision. If you have applied for and see the rules, corresponding rules.
My lord.
Whether there is a deeming provision, suppose you applied for the license, which has been expired, and if the government is hit over, doesn't issue license, but then after a particular time, it is deemed to have been
After a particular
yes.
period.
My lord.
What will be the situation? If there is a deeming provision, if you have applied for it, there is no mens area, you have validly applied for it, your intention is not the
hide
mens area part goes, so you are acquitted.
Mens area for criminality.
Yes. That has to be looked in. Yes.
My lord.
108.
8, my lord.
Done APS.
Mr. Abhay Kumar Sharma now, my lord, additional government advocate. But file left to him, they put on the revision is not 11.
This is the
Permission. For petition, 392, 397, 7 years.
in the year 2011, you were 32. See the judgment, impure judgment.
Judgment, my lord.
Do you have charge sheet?
32. Charge sheet not.
110, no?
Well,
108.
appeal memo, in the revision memo is 32, and when the file appeal, when they are 32.
So that is
Look into judgment, they have written, my lord. Yes.
Don't go by the, you have to go by the charge sheet.
That's not available.
List 2, huh?
Snooping.
1982. Date of birth. In the charge sheet. So must be 82 not. Yes. Non-APS. Let us stop it here. We hear that.
Two small matters, 99 and 100. The rest. 99 and 100 Mr. Perez is small matter. 99 and 100.
Yes, where is Mr. Paranji?
Sorry. Who reason of the arguments? 91 and 100. Around the arguments.
72 item.
99 and 100.
99 and 100 he will come.
74.
Yes, Mr. Sodangi, you have two matters, 99 and 100.
I know, but that is reference.
You are ignoring old matter, you are interested in.
Not ignoring, my lord, so undone.
What to do
Undone.
now? 99.
Tomorrow I
See, 99 is 2011 matter.
Yes,
100 is again 2011.
99 it's a 498 lordship may period under dispute of 100 376 5 years I need the evidence that much.
100. 99
498.
How much you have undergone? You write it down, or probation I'll give.
Pure chakri. Which chakri?
Undergone, just show me the undergone. They the file after this matter you just check it up. Soft copy dekhi debe na apno. From here you just see your
all right. Just now I will do.
And reserve, judgment reserve, huh?
Yes.
Yes. 99 judgment reserve, he will tell the period undergone, PO. Take it.
100 will be available.
100 will be. He will argue. Yes, next.
74. 100 next week.
Not Thursday.
Next week.
100 you prepare.
100 next week.
Yes, 74, huh?
May please allegation against
You are in 172. First item.
Both matters, 199 and 170.
Same
case, only
same
different
case,
persons.
Different persons.
Different
slightly
designation.
different roles attributed. Well, here.
There are how many matters? 1 minute. Let us understand. 99 also. No.
199.
199.
74 years.
Okay.
There is 199.
Then first item and sub item you are appearing.
Yes.
And
172.
282 and 356, Mr.
Only 356.
356. Who is appearing in 282? Nobody appearing.
I am appearing in 172 and
199.
199.
You are appearing?
I am assisting.
Okay. Yes, sir.
Yes, my lord. May it please your lordship. My lords, in this case, the petitioner, my lords, the case is of 2007. We are in 2024 today. Given a date chart also.
Yes.
Well, the allegation against the petitioners are.
Hard copy file.
Mm-hmm.
172. Yes, sir.
Already a period of 17 years have elapsed. Now the allegation against the petitioners are the works were undertaken, some of the works, my lord, somewhere in the year 2003. Now, after 2.5 years, which is as per the charge sheet, my lord, I am only submitting from the charge sheet. There is now a check measurement done by the vigilance squad And they say that there are certain errors in this measure, in the measurements taken by us. Now, my lords, in the meantime, the central government
PM, Prime Minister Gramya Rozgar Yojana. There's a road on it.
and the measurements were also taken by the central agency, National Quality Monitor. They did not find any discrepancy. After 2.5 years, these people come and then they take the measurements and they find out certain discrepancies, whatever they are, my lords. And they allege that a sum of rupees 24 lakhs and odd have been paid in extra. So this is the entire case against the petitioners. Who is he? My lords, he was the assistant engineer at that point of time. Both these persons were assistant engineers at that point of time. There was a junior engineer, as per the charge sheet, he is alleged to have manipulated some of the records. That is the allegation against the junior engineer. And thereafter, it
Junior engineer is also a party here.
My lords,
No, I am the executor.
You are executing.
That is similarly 285 of
He is the junior engineer. Okay.
That is a
Okay. Yes.
Mumbai.
Nobody appears for him. Yes.
Nobody appears.
Somebody appears, but he is not turning up.
Today it's not there.
Now, what has happened? This junior engineer, there is an allegation that he has falsified the records, and we check these records and send it to the executive engineer. And my lords, the measurement is the executive engineer verifies the records and makes the payments.
Yes.
Now, my first submission before your lordship, my lords, they say that grave loss has been caused to the government exchequer.
22 lakhs, 2,628. Yes.
22 lakhs and odd money.
Yes.
Now, if your lordship kindly sees clause 6 of the agreement itself at running page 65.
Yes.
Clause 6, ma'am.
Yes.
The proviso, second paragraph. Provided that, lordship gets it.
Yes, and
Provided that if any balance of the 7% security is outstanding from each such payment shall be deducted so much, not exceeding 5% as may be necessary to make up the balance of the security. All such intermediate payments, this is very important, all such intermediate payments to the contractor shall be regarded as payments by way of advance against the final payment only, and not as payments of work actually done and completed, and shall not preclude the requiring of bad, unsound, and imperfect or unskillful work to be removed and taken away and reconstructed or re-erected to be considered as an admission of the due performance of the contract or any part thereof in any respect, or the accrual of any claim, nor shall it conclude, determine, or affect in any way the powers of the engineer in charge under these conditions or any of them as to the final settlement of adjustment of the
in this case, final settlement has not made.
has not been done, and the final bill which has been, this is an admitted position, and the final bill which has been raised.
Whatever you have paid is subject to final bill.
Final.
The calculation at the intermediary stage is neither here nor there.
So this
That's the thing.
is an intermediary stage. My lords, the final bill that the contractor has raised is for a sum of rupees 48 lakhs and odd. This is an admitted position, my lords.
That is released. That is released.
My lord?
That final bill is not released.
No.
No, the final bill still remains with the department. So how have these persons caused any injury to the government exchequer? This is my first point. Second point, my lord.
Charge is framed.
No, the charge is not.
Discharge application is rejected.
Discharge application we had filed, and against that we have come up with your lord.
Yes.
That was rejected. This has all been recorded in the,
Yes.
my lords, if your lordship wants,
Next point.
Next point is, my lords, after 2 years, the measurements have been taken. Now, this honorable court has held in Viravar Sethi's case, as well as another judge, case, my lords. that
Citation
is,
recovery.
Antony Kishan, this has not been reported, my lords. Bilavar Sethi is reported in Manupatra, OR 0385 2012.
Yes, which para?
My lords, the para is paragraph 8. my lords.
Yes.
What you can say?
Judicial notice.
Judicial notice.
Yes.
Judicial notice can very well be taken of the fact that the concrete road used by the villagers constructed over 4 years back cannot have the same measurement and quality as it had on the date when it was constructed. Further, it being admitted by the then Assistant Engineer Sri Banerjee that the measurement done by the petitioner was check measured by him as was found to be correct. And the Assistant Engineer Sri Banerjee, having not been arraigned as an accused who was the higher authority of the petitioner and checked the measurement done by the petitioner and found the same to be correct, it is seen that no prima facie case for the offences of which cognizance has been taken is made out. And this court further finds that for the above reasons, if the criminal case is allowed to continue, there can be no doubt that the same will end in acquittal of the petitioner. So this was a ground on which the entire
Cognizance was passed.
proceeding was called. There is another judgment by this honorable court, that is CRLMC.
Antony Krishna. Yes.
My lords, where at page 7, let's say, from the inquiry, lordships, the second paragraph.
5 lines from the bottom.
5 lines from the bottom.
Yes.
Lordship gets it from the inquiry.
Yes.
From the inquiry conducted by the technical persons, it is clear that financial loss has not been caused to the government by the lapses, if any, of the petitioner. Further, the inquiry was conducted after about 1 year of the construction of the road, consisting of chips and bitumen work, by which loss might have been caused to the surface of the road during last rainy season, which is a natural phenomenon. In such a situation, initiation of vigilance proceeding after 1 year of the completion of the work for loss of 3,42,597 is not proper so far as the petitioner is concerned. Further, there is inquiry by a technical committee to the extent that financial.
But in your case, there is no technical. In your case, there is no technical inquiry.
No.
It was initiated after 2 years.
After 2
So
years.
to that extent, you are relying because
it was certified
might
with
have
the person's
suffered
substance.
damage because of the rain and all. So measuring after 2 years will not get right.
You will not get the correct measurement,
Right.
and it was certified by the persons concerned at that relevant point of time.
Right.
Everything has been checked and cross-measured. Now, after 2 years, you come with whatever technical team you have, that my lords, they come and measure. Now, their measurement cannot be accurate as held. Judicial notice has been taken by your lordships, and this is another EML plus. The second point, there is no financial loss caused to the government. In fact, 48 lakhs is still being withheld. If ultimately the contractor can prove and that this was falsified, that the entire final bill is correct, he will get his 48 lakhs. Otherwise, the department will deduct this 24 lakhs or not. And take it,
Contractor is not an accused.
My lord,
Contractor is not an accused.
contractor is also.
And power of attorney holder and he is dead.
Power of attorney holder is dead. I mean,
My
after
predecessor is dead. 2 examiners, one is dead.
most of them have died, my lord. I think the IO also might have.
So I'll adjourn it for some time. So the brief will have
Yeah,
a natural
natural
death. Natural death.
So
Yes.
this is our entire case, my lord, subject to.
And
what
why
the-
for this judgment? This
My
Vakil
lord,
Prasad?
We are given copies.
Vakil Prasad.
कौन पे कौन
Vakil Prasad.
Vakil Prasad is for delay in trial. 17 years have elapsed now.
Oh, for that 17 years.
17 years.
And that report has come. Your lordship the other day, let me senior complete.
Yes.
The
Paragraph 50 of Vakil Prasad.
Yes.
It is therefore well settled that the right to speedy trial in all criminal prosecutions is an inalienable right under Article 21 of the Constitution. This right is applicable not only to the actual proceedings in court, but also includes within its sweep The preceding police investigations as well, the right to speedy trial extends equally to all criminal prosecutions and is not confined to any particular category of cases.
You got a stay in this court.
My lord,
You got a stay from this court.
Not stay exactly, your lordship has said adjournment.
Adjournment.
even the direction issued by the High Court seems to have had no effect on the prosecution and they slept over the matter for almost 17 years. Here also, my lords, so almost more than 17 years.
But he not slept over. You
No,
made them to sleep.
No.
My lords, they were intermediate. They could have moved this honorable court and adjournments when taken and they could have moved and this is the
So,
point. Which the
Who had died according to you, Mr.
They are not before lordship.
Then, my lords, this
No,
judgment,
but you tell me, the
all right.
contractor died.
Name.
Another order.
Contractor died.
Another order that I'm placing.
No, I just want to know
Ye
contractor
modification
died.
for certain.
Contractor died.
Natak.
Sudarshan Sahu. There is the power of attorney holder of the contract.
Who was actually executing the work.
Sudarshan Sahu.
Contractor, huh?
My lord. And another one is the Bhattal Krishna Rao.
Bhattal Krishna?
Rao.
He is the original.
He is an engineer, my lord, executive engineer.
He also died.
I succeeded him.
And another is the Bhimmari
You under 394.
No. I was also there as the, no, he was partly there, I was also partly there.
Mr.
Bhattal Krishna Rao.
Bhattal Krishna Rao.
My lord. And another is
Executive engineer, he is no more.
another is Bhimmari Majhi.
He was accused.
Exactly.
Died.
Bhimmari Majhi.
Vimari.
My lord. Bhimmari Majhi.
Mari. What?
ଏଠାରେ
who was
7 ଜଣ
he?
ଥିଲେ.
Bhumari Maji was what? He was official or what?
My lord.
Bhimari Maji.
Executive engineer.
नहीं भूल पूरा.
Be sure.
My lord. Executive engineer is also. Bhimmari Majhi.
They died, huh?
He died.
That's it.
Yes. You wanted to show me something else? Another
Yes,
judgment.
fellow.
That
FIR has been registered on
Tarakanta Mahapatra judgment.
Yes, fellows. Tarakanta Mahapatra, this honorable court has relied on Vakil Singh for stay. Cognizance. At page 5.
Yes.
Now, so under the circumstances, my lords, 3 points that I'm canvassing before your question. First, my lords, these are intermediate payments, no injury caused to the government exchequer. Second, my lords,
No loss to the exchequer because
my lord,
no loss to the exchequer because
No
the
loss-
final payment is
no
still
loss to the
withheld
exchequer when final payment
and
is-
delay of 17 years.
delay of 17 years, and third is, my lords, the measurement was taken.
Measurement
2.5
after 2 years, the
So,
judgment says that
Judicial
never
notice is
corrected.
taken by this honorable court that there is wear and tear on these roads, so the measurements cannot be perfect. These are the three. And my lords, insofar as we are concerned, we have not, if records falsification, which they say, is all
Junior
attributed to the junior engineer. Nothing has been attributed to us.
What, you want to add anything?
Yes, yes, ma'am. So far my party is concerned, your lordship, a list of documents I have filed.
Yes, tell me, what are the points extra?
The documents I have referred to only. Your lordship, kindly have a look at them. Copy. ଆଜ୍ଞା ଆପଣ ପାଇଁ ଅଛି ତ କପିଟା? ଆଜ୍ଞା ଆପଣ ପାଇଁ ସେ ଲିଷ୍ଟ ଅଫ୍ ଡକ୍ୟୁମେଣ୍ଟ ଦେଇଥିଲି ଅଛି? ପଚାରୁନି। ପାଉନାହାନ୍ତି? ଏବେ ଆଉ ଗୋଟେ ଦେଇଦେବେ।
Mr. Sahu, 3 points, both of you, 3 points which the senior has argued. 1, 2, 3, you just note it down and give so that I can correlate.
Only I will clarify the third point. Yes, the report has come. We have taken adjournment for the last 3-4 years. at a certain point of time, when it was fixed for discharge, we have taken adjournment. The reason being, the whole police papers were not supplied to us. So obviously we cannot argue the points raised. That petition was pending. Instead of doing that, instead of supplying papers, it continued. And ultimately, rather forcibly charge was framed. We came up, this is the second round. First round we came up. During pendency, it also caused delay. So reason is not us. They never supplied. When the last application was disposed
You
of.
came to this court and got a stay also? No.
No, because it delayed, obviously, we have to pay for time. Then ultimately they supplied the papers. So this Honorable Court disposed of these applications that now that the papers have been supplied, you should approach the court afresh. We approach the court afresh, then this petition. So the time we have taken, the period, is because they have not supplied.
So out of 17 years, maybe 2-3 years delay by you. But
Because
fact
the
remains-
reason is that your Lordship may see the whole thing. From the date they did not supply, we applied for. It continued. Obviously, we have to pray for time. Before that court, ultimately that court got fed up. Charge was framed. We approached this court. Again, it continued. Then they supplied. So this court set aside that order. You go and approach afresh. Now that the papers have been supplied.
First charge was framed, you got the set aside
Yes.
and went and
Our petitions were disposed of without supplying the documents. We approached, then the court said, now that you have received, you go back. That is how again. So in this process, 3-4 years. And that is what the report says, because the lawyers took time. Obviously, we have to take time. We don't have any option. That is, kindly have a look at the list of documents. I have filed because it's on record.
Suppliers. What is
Right.
that was not complied with.
No.
Suffered delay. Suffered delay.
356 में. That is the list of documents. It's filed on 26/9. Last you got it?
Yes.
The first is copy of the affair. Last you got it?
What do you want to show?
Millards, your Lordship knows when vigilance cases are instituted, they make a preliminary inquiry, collect the materials, then they do it. The affair, though my reference is there, that I was the exudna at page 7.
Yes.
My name is there.
Your name is what is your name? Surendra Kumar.
Sorry, Millards, page 6, last is my name. Subhendu Shekhar Mahapatra.
Yes.
But I was not an accused then.
Yes.
Second page, column of accused persons. I was not an accused then. After the inquiry, affair was lodged. I was not an accused in the affair. Then this is under the Pradhan Mantri Ramya Shodok. So they have their own notifications according to it, what has to be done. Now, exudna is the head of a division. These works are done under the subdivision. But financial head, being the exudna, ultimately bills are to be signed. That is all. In addition to that, there is a specific allegations against me. Though there is that some pitch road, I have converted into cement roads, a patch of it. That is the reason I'm pointing out the document. The notification itself permits, it can be done, but the cost should not be more than the cost what is given for the road. And intimation has to be given to the superintending engineer. In case a tree is coming, in case some house is there, in case there is some obstruction, in case it's a flood hit area. So that power is given.
That is the scope of the trial.
No.
In case, if, but, and everything will be
Not in case,
sorted out with
Millards.
the trial.
No, not straight jacket, Millards. They say,
Why are you going into all these things? If they can't answer these 2 points, you are out. Unnecessary, why factual controversy so much? If you take me to lot of factual controversy.
not factual controversy.
Then you should face the trial and sort it out there.
Millards, it's not factual, any controversy. I said
They
nothing
may
wrong
be
has
something
been.
else.
wrong has been committed by
And
this
you are
person.
relying on many documents which may be
Not-
not whether it is part of record or
Yes.
not part of record. How do I know?
Well, charge sheet is there. I have stated so. It's part of record. How can you go beyond that?
These documents which you are relying is part of record?
Everything, yes. These are all part of.
They may contribute.
Cannot.
So show me the
Charge sheet, yes.
entire charge
Yes. It's
along
there.
with the document.
Because I have extracted it for, because the whole charge sheet will take one day. To avoid wastage of time.
Documents are relatable, you know. One document is relatable to the other. The document which are favoring you, you might have picked up those documents and filed. The other
He
document may be
can,
something.
he is there to point out.
Then again, at the charge stage, I don't think I can go into it. I can't conduct a mini trial looking into each
No,
and
no,
every document
no.
and find out a trial court has done it already for you.
Not a mini trial, I am not asking for. I know my limitations. This court cannot go into sifting of evidence, assessment of evidence. I am not saying that. I am saying that it's all within my role, what I have done.
Next point.
Because the sanction order, or you may see, that is specific. What I have done.
Wait for a while. Let us see if the
All right.
4 points
All right,
which
Mr.
learned senior has pointed out,
All right.
whether they are coming over those points or not. If they are not coming over, they are out. I need not go into all this.
No,
Let them. Yes, Mr. Das. You the first 4 points you have to get over.
Your Lordship, kindly grant me at least on this top. The way I prepared for, then I'm duty bound to answer all the queries. And I've understood the points. I hope I'll meet all those things, Lords. I'll not flee of him, Lords. But these are the 4, 5 cases, so many factual aspects and so many things are there. But at the outside, my Lords, I'll just place for Lordship one paragraph, my Lords. What are the charges? What are the allegations against them?
Yeah.
Deal with clause 6 of the contract. Yes.
Because
Yes.
accused persons being public servants while performing their official duty, the capacity of assistant engineers, junior engineer, entered into criminal conspiracy with other accused persons, namely the contractor. In pursuance to the same, they not only executed substandard work, but also recorded inflected measurements in construction of Dorosai Bodok Road. Thereby, they made illegal and wrongful gain to the contractor to the tune of rupees 25,05,898. This is in the charge sheet. Resultantly, there was wrong.
So let us point out. Let us give again. What are the allegations? First allegation is measurement.
They work in a tandem to has the conspiracy, and the first allegation is that substandard work, which is
work and inflated measurement.
Measurements.
These are the 2.
And also gain and peculiar advantage to the contractors.
That's culminate into that.
Your Lordship, turn to the next page, please.
Yes.
Accused persons in these applications have prayed for discharge on the ground that there was no sufficient ground to frame charges. Materials collected during investigation not only raises great suspicion, but also establish sufficient grounds for the same. On inspection by the vigilance technical team in presence of the accused person, it was found that 1, the quality of work executed by the contractor was not in confirmation with the specification. BT road. BT road stands for bituminous roads. Bituminous road work have been executed in place of concrete roads with an approval of the competent authorities. Less thickness and grade to the metalling, sand layers, GST, and important line plots. The measurement book, MB, the measurement book was examined by the GQ, the government, and the figures in MGQ in page number 23, 24, 68 were found tampered. Then, Lords, despite substandard work executed by the contractor, the erring officers, accused persons consciously certified the same, and accordingly, the running bills were passed from time to time and were paid. On account of willful and deliberate criminal misconduct by the accused persons, huge amount was paid in excess, which constitute the offense alleged. I repeat, my lords, with your lordship permission, my lord, on account of willful and deliberate criminal misconduct by the accused persons, huge amount was paid in excess, which constitute the offense alleged. Subsequent adjustment or recovery would not absolve them from the criminal liabilities. These are the allegations against the lords. And with regard to my lords, with regard to
1 minute, 1 minute. The two things which are coming apparently. One is page 23, 24, and 68.
Have been
Of
manipulated.
The MP record was found tempered.
Yeah, and that is
one allegation.
and that is also supported by the opinion of the
And second allegation is
substandard works.
no, substandard work will not
To be
criminalize.
very specific, in lieu of concrete work.
You have a contract, you have an arbitration clause.
Yes,
and
but
everything you
I'm specifying, my lords, in lieu of concrete roads.
1 minute. Certified the same and running bills were taken.
Yes, and my lords, and the important line, my lords, in place of concrete road, without approval, my lords, they did that BT roads work having executed, my lord, bituminous roads, my lords, pichipoke installations. And my lords, this was done by the Vigilance Technical Committee in presence of the accused persons, my lord, and the allegations. My lords, let me place. I can't improve my case, but whatever but I'm duty bound to place all the matters on behalf of the prosecution. These are the specific allegations. As I agree with lordship, has understood the points, my lord. Main allegations, my lords, they work in tandem to has a conspiracy. One, to enable the contractor to be benefited. Obviously, my lord, the booty is to be shared. And my lord, the second point, my lords, they did mischievous things in inflated recordings, my lords. Inflated recording, that too, my lords, manipulating of the recordings in that MB books was tampered, my lords. And they examined by that export authorities, page 23, 24, 26, my lords. And my lords, they also paid the money, my lords, in abruptly, my lords, so that and the third point is, my lords, recorded inflated measurements and, my lords, manipulation of that measurements, my lords. My lord, these are the specific allegations.
Please answer me specifically.
My lords.
I am accepting your argument to be correct. I am accepting your argument to be correct. Equally, I am accepting their argument to be correct. They are the accused. On the strength of their argument, can you convict them?
No, that is,
they are thieves. They have done everything. But how will you convict them? Why should you put them to trial? Because you don't have any material.
No, I have got the materials which disclose great suspicion with regard to the individual complicity. Now,
How will you get over 6?
Yeah, lords may put me the question, what are the individual complicities, my lords? I am placing, lords.
Yes.
I will not place, similar statements are there. I will place only few. I am holding that draft.
Some paper book you are reading?
No, no, statements, my lords.
You have a weak evidence. Rather, there is no evidence.
But I am very positive, my lord. We have to work with the positive attitude, my lords. Yes. We can't get 100% perfect case, my lord. Perfection is rare.
So this is what is there on the record?
No, my lord. This is the statements of the yeah, lordship, I'm placing that particular statements of Sri Bikram Keswari Lenka, my lords. You lordship got it, my lords?
Yes,
the name is the Bikram Keswari Lenka. He is the assistant executive engineer, my lords. I'm placing, my lords. Similar statements are there. I'm placing 1, 2, my lords. During my incumbency as a assistant engineer, Basudevpur roads RW subdivisions, the alleged work package number OR 1411 was executed. Road B, so and so, Karunakaran roads under this package was executed under my jurisdiction as both the works, that is Dolosai, Bhadrak and Kuarma, so and so are under one package and one agreement. That's important line starts. So I have prepared the running bills after receiving the check measurements, measured MB from the SG of Bhadrak. The payments in the Dolosai Bhadrak road have been made by 2nd, 4, 5, 6, 7, 8, and 9th running account. See Sambusi Acharya, J. one of the accused with the petition for lordship, my lords. What role he played? My lords, of the other section has measured the entire work in which payments have been made. And my lords, the measurement book was also handled by him, my lords. Say Santosh Kumar Samal, the another petition for lordship, assistant engineer, has check measured the work up to 5th running running bill, running on accounts, my lord. Then Santosh Samal is also here, my lords, in this list, my lord. Prakash Kumar Bol, another accused, my lord, assistant engineers, has check measured the work up to 9th running years. Say Suvendu Sekhar Mahapatra, executive engineer, has passed the bill up to 8th running bill. And see B.K. Rao, my lord, executive engineer.
So these are the executive engineer those who passed the running bills.
Yes, two.
But measurement has been done by the assistant engineer.
Measurement by 2 and measured by 1. He's correct. Measured by 1.
All these people.
And my lords, check measurement by 2. Measured by 1, that Sambhuji Acharya, he created the measure everything. And then my lords, the Santosh Kumar Samal, check measures up to 5th RI. Prakash Kumar Bol, another petitioner for lordship, up to 9th, he check measured up to the 9th, my lords. Suvendu Sekhar Mahapatra, executive engineer, passed the bill up to 8th.
They are admitting it.
My lords.
They are admitting it.
My lord, my humble submission, my lord, this is not a groundless case at the stage of consideration of discharge application. These are the materials definitely indicates their complexity. Their complexity.
Try to appreciate one thing. These are not disputed facts. They are also admitting that fact. What they are trying to say, two things.
They have said, my non-friend has stated
1 minute. Let me.
three things. One is one.
Let me come up. Let me what you call formulate it. One thing they are saying, these measurements are wrong. However, the measurement is obviously to be wrong because it has been done after 2 years. First question. Second thing is, they say,
no financial
even if it is wrongly done, then it is the bills which were cleared by them are at the intermediary stage. So clause 6 of the contract says it is not to be treated as a final thing. So obviously wrong thing will be done, and so final bill you have withheld. So where is the criminality? That's what they are arguing.
Criminality starts, my lords, even subsequent adjustment and recovery would not observe them, my lords, from the criminal liabilities. With great respect, my lords. Subsequently they adjusted or recovery would not observe them from the criminal liability. That is my submission, my lords. This is not a case, my lord, where absolutely no ground is there. There are materials to proceed, my lord. Yes. And the lordship may put me a question that and statements, but the lordship may turn to that green flag, my lords. That's the report of the inspection reports, my lord. On the last page, that green flag, my lords.
Inspection report, yes.
That's inspection.
Yes.
Your lordship may turn to page 5, my lords. The last page, my lords.
Page 5.
Last page, my lords.
Yes.
Last but 1 5 on the bottom side.
On comparison.
No. Let's turn to the bottom side. I put some pencil markers.
The concerned JE and AE and this one.
No. Let's say that. Yes, but I think that's the last one. Last paragraph, my lord. That they did bituminous work. They executed bituminous work, which is adheres to the agreements, and my lord, in lieu of concrete roads, my lords. And without the competent authorities permission, my lord. And this is not a fair play, my lords.
Cut their bill in the final stage.
No, my lord. Final pay should wait that criminal activities to continue, and after they complete the entire criminality, then we'll go for a check. No, the check is always, my lord, in the midst without their notice.
Violation of a contract condition cannot be any.
My lord, this is at the same time.
Contract condition, you say this. You should do this road, they have done that road. It's a violation of contract condition. Where is the criminality into it? I don't understand.
Criminality starts, my lords, the way they, my lord, another important aspect on record, my lords. They are also involved in that particular measurement book. And in the charge sheet also, my lords, they have stated, my lords, that.
Who has manipulated page 23, 24 and 68?
That Sambhuji, my lord, the JE, my lords.
Do you have that specific allegation against any one of them? That these 3 pages were manipulated by this gentleman or that gentleman?
No, my lords, they work in a group, my lords. They work in hands in globes, my lords. They work in tandem, my lords. So this is a part of conspiracy, my lord. Every person has some role to play, and they played effectively to the extent, my lords, that it's all. I'm placing that page 57 of the criminal ledger 172 or 23, my lords. It unequivocally indicates the alleged work was technically inspected vigilance technical wings in presence of the petitioner accused Sambuji Acharya, junior engineer, on 19/9/2005. It was found that rupees 25 lakhs so and so has been paid in it. It is also ascertained that the figure in MB in page number 23, 24, 68 have been tampered and changed, for which there is error in the calculation. As the work was ongoing and the measure book was with the J, and when the vigilance started inquiry, he has manipulated the entries. This has also been proved by the GED. What more materials, my lord? This sufficiently indicates their complicity, my lords. And my lord, what is the degree of role they played, my lord? That may differ. But they had the unanimity of minds, my lord, the criminal intents, my lords, to facilitate this contractor to get the extra amounts, my lord, at the cost of state exchequer. My learned friends submitted that there is absolutely no financial law. It is absolutely wrong. That's he has been paid, my lords, and in part he was unjustly enriched, my lords, and in part he was paid more than his due, my lords. My lords, in fact, the another point, my lords, I like to praise my learned friends submitted about the speedy trials, my lords. My lords, I gave your lordship permission, my lords. Lordship may permit me to place 2 pages. I'll not take much time, lordship. Kindly permit me to place this one. These are the legal principles, my lords. With regard to my lords, section 23 CRPC, my lord, not dealing with now that import order emanates from an application filed under section 239 CRPC, my lords, and the legislative language engrafted there, my lords. Magistrate consider the charge against the accused to be groundless. He shall discharge. It's not a case of groundless. 2. Section 227 also, my lords, unequivocally state sufficient ground for proceeding law. Now, lords may turn to the first ground. Your lordship is aware, but still then I will place for my satisfaction and to lordship consideration. At the stage of consideration of discharge petition or the framing of charge, hearing of this submission of the accused has to be confined to the material produced by the police. Thus, the pleas based on defense documents do not form the part of the which do not form the part of the charge sheet cannot be considered while considering.
That precisely I have asked Mr. Chaudhary, whether these documents are part of record or not. If anything is not part of a record, I can't rely upon a document which is not there and find out.
It's not.
Which documents are not part of recording?
After 33 years or 35 years, these basic fundamental errors
I am on that point, my lord. The concept of speedy trial, how that will be placed in service in the application.
Speedy trial, they're entitled to. If the delay is attributable to them, they are not entitled.
Lords, we can have the glance, lords. Lords, we can. Lord, I need not repeat the entire line. I place in one line. This is the landmark judgment of Supreme Court. So far, consideration of discharge application is concerned. That is State of Odisha, Devendranath Party, my lord. I am placing, lord, the flag mark, the green flag mark. I am placing one line, my lords. One line, that is the para 8 last line. The expression hearing the submission of the accused cannot mean opportunity to file materials to be granted to the accused, and thereby changing the settled law. At the stage of framing of charge, hearing of submission of the accused has to be confined to the material produced by the police.
ଅଧା କୋର୍ଟରେ ଚାଲୁନି ଏଠି ଝରକା ବି ନାହିଁ.
Who has to be blamed? You people have to blame. There is no facility of fairness also. Take the responsibility.
I can answer that, but.
No, don't answer it. Huh? No, the problem is the design is such, you will be surprised there is no fan.
Original design टा ସେଇଠୁ ଆରମ୍ଭ ହେଇଥିଲା।
At least there should be, when you know, after the court hour, if all the lawyers are going and the AC is running unnecessary, that area is completely chilled.
No, it's not running, Millers. Now it has stopped running. Outside.
When it is required, it is not running. When you will go, then it will start running. That's the design we have. It's very difficult to work with this kind of, you know.
ବାହାରେ totally ବସି ପାରିବେ ମାନେ ଚାଲିବି
I know. Very difficult.
ଆଉ ଝରକା ଖୋଲିଲେ ମହୁମାଛି ଏତେ ଏତେ
No,
ବଡ
there is no ventilation also.
ଝରକା ଖୋଲିଦେଲେ ଆଜ୍ଞା ମହୁମାଛି ଏତେ ଏତେ ବଡ ସବୁ ମହଲାରେ ଅଛି ଗୋଟେ ଆସିବ ଯଦି ସରିଯିବ ସବୁ ଆମର ଅବସ୍ଥା।
That could be a good ground for adjournment. Yes.
May I proceed? Your Lordship, may kindly peruse that last line of paragraph 18.
Can we continue tomorrow?
Yes, Lord.
I'll continue tomorrow.
I'm deeply obliged,
Let it-
Lord.
let it continue.
In fact, yesterday, my lords, yesterday midnight football match or Euro Cup final, in fact, took out everything from me, my lords, because they will be reacting, my lords. I said yes, my lord. Otherwise, I could have prayed for adjournments. My lord.
Don't get scared.
3 hours in the night, my lords, I'm not getting adequate sleep, my lords.
No, but you, whatever documents you are relying upon,
I'm taking
please
back.
give a photocopy so that I can.
Yes, sir.
My lord.
No, you are smiling now. The flash of smile on his face, my lord.
You
My lord.
made him to work and that's what he says.
Mr. Kanunga, with a flash of smile on his face, my lord. He said, look, he's tired and pale and miserable, my lord. Absolutely full of energy.
He never takes pressure.
Yes, happy man. Sir, in our college days, we used to call him the extraterrestrial. Because when I entered to his house and when I was in first year, so he was doing boxing.
Even today he's capable of doing it. Don't go to his house.
I still doubt.
He may use you.
Now the problem
Millers, before party, the list of documents I have filed, your lordship wanted me that if at all he's going to those
These are
things,
compilation, please.
I have given. These are all part of it. Let him verify so that he will say if it is outside or something.
No,
But see, what is troubling
property
me?
value of the documents cannot be gone into. Clear.
Millers,
No mini inquiry is
I answered
required.
the
If there is any shade of
You are right, you are
materials
absolutely right.
disclosing any grave suspicion, the revision
That's the problem is, I am agreeing with you fully. Equally, I am agreeing with them fully. So where you are going to lead?
then my lord, the venue
They
should
will be acquitted.
but the venue should not be revisional venue. The venue should be 482, 226.
There you may be correct. There you may be correct.
482 Millers, no application is required or a nomenclature is required. If the court feels like court can
Or
include.
I will place Mila. What is the so Supreme Court has come down, Mila, rejecting a decided application, framing a charge at one and same process, Mila. And what is the scope? No appreciation of any materials on record. Only in the pattern error of jurisdiction that can be raised, Mila. That Supreme Court has come down, Mila, not only in one case of Asian separate. That was followed until last 2 years also. So that on the scope of that, the scope of revisional jurisdiction,
Okay, still you have to
interpret is
overcome
absolutely
there two arguments. You have to overcome that two arguments.
no financial loss, no financial loss. And second thing is that that measurements 2 years after lots. And the third thing is speedy trial.
And clause 6 of contract.
Clause 6 of the
Arbitration.
Contract on the basis of which the work was supposed to be executed. That clause 6 is very clear. It said in the interregnum stage
That they can
the measurement and everything may be wrong. And the bills are passed, that may be wrong. But if it is wrong, the contractor may be asked to redo things.
No.
Redo things and
Milord,
it will be adjusted in the final bill.
Milord, the point is, Milord,
And the case was instituted halfway down.
That is what.
The government also is not
That was
recovering contractor. Although recovery they could have kept the final bill. The final bill is also kept left.
And the contractor has died.
Contractor has died. So.
In all criminal matters, in all criminal matters, they will be agreeing with me. In most of the criminal matters, हो गया तो हो गया ठीक है लेकिन जो इसको ratify it, what in which way subsequent listen subsequent adjustment is a plea available, not subsequent recovery, and it could have been done, would have been observed them.
General principle. If there is a theft.
Correct, blocks.
If the payback money
Agreed,
doesn't go.
Agreed.
That's not the issue. Issue is
That will not observe them.
No. Issue is it is a execution of a contract.
Matters.
Watertight clauses in the contract is there. If there is a violation of the contract, if the work has to be done in accordance with the contract, if there is a violation of the contract, then can the criminality can be fast enough on them or not? That's the whole issue.
The contract never stipulates that you go and manipulating by measurement book.
So you show me.
The contract never stipulates that you do.
Show me that
measurement is correct.
Show me that instead of laboring in general principle. General principle is known. You show me that they have done this criminality.
Yes, not correct. Will also correct.
Exactly those things you show me. They have manipulated this document. Show me those documents which are manipulated. Overwriting they have done. Overwriting you show me. These are the criminality.
Correct.
General principle everybody knows. You can keep on talking for 2
Speedy
days.
trial is being placed into service in a application in a hearing.
They are hiding behind a contract.
Matters.
They are hiding behind the contract in the absence of the contractor who has already died.
Like contractors say, the contract says that you do concrete road.
For that remedy is there in the contract itself, sir. You just see. If they have done concrete work, the government can force them to get the work done.
That I can show documents.
Where is the criminality?
Tomorrow
they have permitted bills. Documents are there. They have permitted.
The contract says if they have done wrong, the government can force them to get it done once again.
Government can also stop it immediately. And we did that, allowing them to go unabated. That at the end of the day, everything will be adjusted, recovered, and everything.
Whether these people are proceeded departmentally?
No.
Ought to happen. I agree with Lordship.
Complete dereliction.
Yes,
complete dereliction of duty on their part.
Correct.
They should have been proceeded departmentally instead of prosecuting.
Instead, this project is
long and short
the
of
project is of the central government. Do it immediately as early as possible. Even the contractor, because of that, they
You should have been suspended. You should have been proceeded departmentally instead of prosecuting. Prosecution will not face
without any.
That's the mistake they are committing. Anyway,
may I pray one another thing also tomorrow. There should the 409 is there, my lord. The charges, my lord.
May I pray one thing, Lord?
You,
May I pray one?
How can I miss?
I know 140, Lord.
Tomorrow 2 o'clock or let it be one day. Then
Wednesday is a holiday.
18th.
Item 140, Miller. I have the information from the my friend in lower court, Miller, that he has suffered the entire sentence, Miller. My lawyer friend can take instruction to that effect, Miller. Did it come in one of capture my lawyer friend in state? 140.
140, just check it up. Mr. Ragada, 140. He has already undergone the entire sentence. 140.
He may take instruction thereafter.
Criminal appeal hai.
The criminal revision hai.
Revision, 140. Just check it up. He has already undergone, we'll dispose it up. Okay. Thank you.
They cannot 409.
Jyotio.
Yeah.